conditions and poses a substantial likelihood of physical harm to self or others as demonstrated by, so it is not a short definition. Oops, not letting me. There we go. Failure to obtain necessary food, clothing, shelter, or medical care as a result of the impairment, or recent attempts or threats to physically harm self or others. So you can see that this is a pretty high threshold. You'll see people on the street that might be homeless, or somebody maybe is walking around and they look disheveled, and people will talk about, well, they're schizophrenic or they're hearing voices, but they're not harmful to anybody, they're not harmful to themselves. They're still able to get food and clothing and shelter and provide care for themselves. As long as they can do that, those patients can't be committed. So I want you to keep in mind that when we're talking about the law, for people to be confined, they have to meet a very high threshold. If they're not able to take care of themselves, or if they're attempting to physically harm somebody or themselves, those are the patients that are going to qualify for commitment. When we talk about, well, I'll talk about this in a minute. So I wanted to start with those definitions to kind of give you a framework for mental illness. Where mental illness fits with the law is the principles of bioethics. You guys had bioethics? I think most of you have had it, so this might be a review. Remember there are 5 different concepts. Beneficence is the duty to act to the benefit of others. Autonomy is the right to make decisions for oneself. Justice is the duty to distribute resources equally. Fidelity is maintaining loyalty and commitment to the patient. And then veracity is the duty to communicate truthfully. And so when we think about patients with mental illness, one of the things that I see from a legal perspective is we're really impinging on the autonomy and also the veracity. There are many times where patients, we communicate truthfully, but we're not always fully disclosing. But the one that really impinges on the patient is that autonomy, the right to make decisions for oneself. And so this is going to be a little bit of a revisionist kind of thing. I'm going to talk about our human rights and our fundamental rights. As a U.S. citizen, we're given the right to life, liberty, and the pursuit of happiness, and that's our civil rights. Patients have certain rights, and those rights are the self-determination or autonomy, privacy, and freedom from restraint. And where do those rights come from? They basically come from our Constitution. And in Minnesota, the law requires, well, not Minnesota, but the Centers for Medicare and Medicaid Services, which is the federal government, for hospitals that are complying with CMS, they need to provide a patient bill of rights to the patients. Minnesota Department of Health says we will provide all patients with a patient bill of rights. And so these are the 3 things that really are over-encompassing of those bill of rights. And that is the right to autonomy, privacy, and freedom from restraint.
I'm sorry, I'm just curious. They said it varied by state. For voluntary inpatient, do they still need to give them the Bill of Rights? Because in other states they don't have to.
Yes, in our state, every patient is supposed to get a Bill of Rights.
Okay.
Minnesota is one of the states that you'll find in many areas of healthcare leads the nation. We were the first state to require hospitals to report serious adverse events. We're one of the first states to publicly report those events. So you'll find that Minnesota really has some progressive healthcare type policies. So the U.S. legal system, I want to talk about that too a little bit. And if you're bored, let me know. I can just move to the end. But I think it's a nice background because one of the reasons why I went to law school was I would always hear, well, we can't do this, we can't do that, the law says this, the law says that, you're going to get sued. If I said, you know what, I'm going to go find out for myself, because you guys are nuts. Because I would see patients. Some patients would be committed and other patients wouldn't. And a lot of times on the med-surg floors, we were putting patients in restraints because, well, they wanted to go outside and smoke or they wanted to go do something else. And it was like, can we really do that? Or, you know, if a patient was wanting to leave before they finished their antibiotics and they had pneumonia and the doctors wanted them committed so we could keep them there to get their antibiotics. Now, this is a long time ago. So, but it was always in the back of my mind, what does the law really say? So there are really three different types of law. You've probably heard of criminal law, so that's somebody murders somebody or robs somebody. They're crimes, and criminal law is really there's a statute, we violate that statute or that law, then you get in the criminal system, and you can be arrested, and you can be detained, you can be put in prison. Okay, so you can lose your freedom. Civil law is, if you think about torts, which are really the malpractice claims, if you know, if I hit somebody in the room, that person could sue me, it would be in civil court, so they can sue me for those damages. So it's more about a person suing a person versus the state taking somebody into custody. And the consequences of civil actions are typically monetary exchange. You know, the person who's found liable has to pay something. If you're in a car accident and you want to sue the other person, that's a civil case. And then there's the administrative law, which is things like immigration, Social Security, tax law, workers' compensation law. Those are all considered administrative because there's a set of rules, but there's an administrative law judge that makes decisions about if there's cases where there's discrepancies or competing ideas. If you get hurt at work and your employer says, no, you weren't hurt severe enough to get workers' comp, then you get into the administrative court with the administrative law judge making the decision. So those are your basic three areas of law. And I probably already talked about these. I went through those. Felonies and misdemeanors are the two types of criminals. You can go to jail or prison. You could be fined something, and it's a government against the person. And the one thing I want to really impress upon you with criminal law is you're found guilty or not guilty. And it's not that you're innocent, it's just that we didn't find you guilty. The person still may have done it, we just couldn't find them guilty. And part of it is because you have to prove beyond a reasonable doubt. And that's a pretty high bar. So for a jury, it's like 99% confidence that we think this person did this. So it's a really high bar to set. With the civil law, we're looking at violation of rights to others, and it's person to person. You're looking at liability or not liable, okay? So there's no guilt or innocence. It's, were you liable or not liable? And that liability is, was it your responsibility or was it not your responsibility? So let me give you an example. If Lori was to hit me, and I could call up the police and I could say, she hit me, that's assault. They can come in, they can arrest her, they can put her in prison. I could also sue her and say, well, she has to pay for my broken jaw. And so that would be the civil liability, whereas she would be criminally guilty. So does that make sense?
I have a question, and it's totally just related to that. If somebody is not guilty on the criminal charges and they're guilty in the civil, how does that make sense?
Okay.
I don't get it.
So here's how it makes sense.
Okay.
If you're liable or not, you have to prove more likely than not that you were responsible, okay? So how that works is it's about 51%. So with O.J. Simpson, and he, was charged with murdering his wife. So they had to convince the jury beyond a reasonable doubt. And the real key word there is reasonable doubt. You can always have doubt, but is it reasonable? I've said on juries before, and people are like, well, but what if da-da-da-da-da? And I'm like, if you have to go that far into creating doubt, it's probably not reasonable doubt. So that's how he was found not guilty. And that's why I said it doesn't mean you're not responsible, it doesn't mean you're innocent. It's guilty or not guilty. And you're guilty or not guilty of violating that law. And the reason why it's such a high standard is we're taking away somebody's fundamental right to freedom. Okay, nobody says we have a right to money. So when you get into the courts with the tort system, the liability, you're not taking away people's freedoms. And so that is a much lower standard. So when O.J. Simpson was found not guilty, the family of, the children that were surviving sued on behalf of the children. And so he was found liable, which that jury said it's more likely than not that he probably did it. So he's liable, so he has to pay this monetary settlement. So that's why the two are very different. is with one, it's a very high stake because you're taking away somebody's freedom. In some states that have death penalties, you may be taking away their life. So we really want to make sure before we take away somebody's freedom. Does that make sense?
Deb, I just have one question. When you were giving the example of me hitting you, you said that would be assault. Now, our book defines assault as threat and battery as physical.
Physical touch.
So can you clear that up, because I want my students to know the correct definition.
Okay, and it will depend on the state. That's probably not going to help you, but in some states, assault, there's first degree assault, which is that threat. Second degree, third degree, and the fourth degree would be battery. And so if you look at federal law, which is the common law, it's really batteries where you're actually touching that person. Assault would be the threat of harm, and it has to be a threat of imminent or not imminent. Well, it does have to be imminent, and it has to be something that would be something that I would find offensive. So it doesn't have to necessarily hurt me. So if somebody threatens to spit in my face, that's something that would be offensive to me. And so that could be that assault because it's a threat of, kind of spitting. Go ahead.
So my students frequently ask me, then why is it called sexual assault instead of sexual battery? That's really confusing for students.
Well, and it's very confusing for attorneys. Again, it goes by the states. Some states will use the term sexual assault because they don't use battery in their state laws. Okay? They just have different degrees of assault. And in some states, there's assault and there's battery. Most states are going to have assault and then battery. There's a lot of theories behind sexual assault because there are a lot of states that don't have rape because we just have first, second, and third degree sexual assaults. And when you talk to the legislators about why don't we have rape in our state, well, it's because that sounds so horrible. Well, I think it should sound horrible. And I think using the term assault is one way to soften the battery piece of it. So the thing you have to realize about the legal system is the laws are voted in by legislatures. And there's a lot of negotiation on how the law gets into the system. So it is confusing. Typically, like the book says, assault would be the threat of offensive touch, and battery would be the actual touch itself. So if I go into a hospital room and I threaten the patient and I say, if you don't behave, we're going to put you in restraints. That's assault, because I'm threatening to touch that person in a way that is offensive to them. If I actually do that, then that would be battery. Now, that becomes a tricky line. Usually if the patient is out of control and they meet a certain standard, you're not going to be charged with assault or battery. Could a patient sue you for that? Probably, but you probably wouldn't find an attorney that would take that case. The one thing I found out about attorneys is they like money, so they only take cases where they can make money. But that's a good point, and I actually am going to talk a little bit more about it, but it does depend on the state that you're in. And I don't know of any state, well, there are some states that call it sexual battery, but in some states it's sexual assault. So it was confusing. It was confusing on the bar exam. But
Well, I've just had so many questions from
Yeah.
students, and I always say, wait until Deb comes.
wait till, and it's a good point. In some states it is assault, in some states it's battery. But if you're going to be taking, if you look at, like, the textbook is looking at what's with federal law covered, and that's the other piece. I mean, we've talked about these different types. There's the federal court system and there's the state court system. And so federal law is kind of the law that's the general law, but then you'll have states that do things that are different from that. Typically, like when you get your nursing license, once you get your license, you can go to any state, you apply for reciprocity, and you don't have to take your NCLEX exam again. You're like celebrating. Well, I took my bar exam in Minnesota, and then I went to Alaska, and I had to take the bar exam there. Because federal law might be the same, but how it's applied in Alaska is different than how it's applied here, Alaska law is way different than any other law anywhere in the world. So you have to you can't just go from state to state, you actually have to take that bar exam. Now the legal world is moving towards more of a consortial arrangement where if you've been an attorney for so many years, you could go ahead and get reciprocity in those states, but not all states do that. Like California, if you want to practice in California, you have to take their bar exam. Part of it is they want to keep people out. Like in Alaska, it's 50% pass rate, so it's a pretty tough exam. So at any rate, that's a long explanation behind why is assault and battery different and why you see it differently. But if the rule of thumb is that it's assault if you touch or if you threaten to touch, offensive touch, and it's battery if you actually complete the touch. And then there's the different degrees. Okay, so we've all got it with the legal system. Criminal, I could be arrested, I could go to jail. For civil, I could be liable or not liable. It's a very low threshold. It's proved more likely than not. There's another one that's preponderance of evidence, which means it's about a 75%. It's still in the civil area, but it's just a higher threshold, and it gets very confusing to people. We don't need to worry about that quite yet. The one piece I want to talk about is the torts, and I want to talk about negligence. Negligence is where you have a duty to somebody and there's a standard of care and there's a violation of the standard and then that standard causes harm. And then in the case of malpractice, it's professional negligence. So let's say St. Catherine's has a duty to keep the sidewalks clean for all their students and for people who are on their property. And they violate that standard by not keeping the sidewalk clean. And so somebody's out there and they're walking and they slip and they fall on the sidewalk and they break a hip. Is St. Catherine's liable for that person's hip injury? Their fall caused harm. And so in most cases, yes, there was a duty, they violated that duty, that duty caused harm. It's in regular court, so it's just a simple negligence claim. Now, you will find cases where if you have a good attorney, they're going to argue, you live in Minnesota, it's cold, you can't always keep the sidewalks icy. This person should have been wearing shoes that, had clamp-ons, and you'll find juries that will say, no, they're not liable. They did the reasonable thing, they had their sidewalks plowed, we got a freak ice storm at 1 in the morning and they didn't have time to plow it, and so they're not liable. So that's where you get the debates. I was up in Alaska and you can't have slip and falls. I mean, it's just accepted that it's slip up there and you better put on the right shoes. And so you would rarely ever see that happen. In malpractice cases, there's going to be a standard of care, and there's the duty to the patient. You have to have a duty to that patient. So the patient comes to your hospital and you accept that patient for care and you're providing care to the patient. And you have certain standards, and some of the standards are that you check patients for their fall risk, and if they're high fall risk, you make sure you have somebody escorting them around, you make sure you have somebody taking them to the bathroom and staying with them so they don't fall. Well, let's say we were really busy and we couldn't get to that patient, the patient decided, I can't wait, I gotta go to the bathroom, I'm gonna get up, I'm gonna walk to the bathroom, I slip, fall, break my hip. Okay, so let's say we violated that standard. Who establishes that standard?
The legislators.
Nope. But it's a good shot. So think again, legislators create laws, that's criminal. In tort world, civil world, it's case law. So there is no legislative laws that say what the standards are. So I'm glad you asked that question because that helps me explain a little bit more about where does the law come in the civil world. It comes from all the cases that have been tried before.
The facility?
The facility might have a standard of care.
Professional organizations.
Professional organizations might have a standard of care. So if I'm educating the jurors, because that's what I would do in a civil trial, I'm going to bring in an expert witness. So if you have a malpractice case, it's professional negligence. The idea is that your jury's not going to know what the standards are, so you bring in an expert witness. And the expert witness, you have one side for the plaintiff and one for the defense. The expert witness is usually going to be somebody with a doctorate or a master's degree. They're going to be a clinical specialist. They're going to be a nurse in that area. If it's a case, in this particular case with falls, the people who are suing are going to bring in somebody that's an expert in falls prevention. And the hospital might call one of their nurses and say, but this is our standard. And their standard may not be consistent with the national standard. So then which standard do you go with? What do you think?
Whichever benefits the person on that side.
Which standard is the jury going to?
The national.
The national standard, whatever the community standard is. There was a real famous case a long time ago where it was with voting, and the voting standards were so low, the judge said, you guys are setting the standards low. I'm throwing this out. You owe a duty to the people. So they look at national standards. They don't look at your hospital. So your hospital could say, well, I'm following hospital policy, but if your hospital policy set a standard that's not consistent with the rest of the standards, that hospital is vulnerable. So the point about this is that with negligence, with regular negligence, you don't need an expert witness, but with malpractice, you need a professional to come in and set that standard of care. Does anybody want to take a guess at what negligence per se is? It's okay. I don't expect you guys to know. What it means is basically negligence, it's a violation of a law. So I don't have to bring in an expert witness. If there is a law and I violate it, it's negligence per se. So I'll give you a real good example. Do you guys know HIPAA? You guys probably learned HIPAA, and you can't disclose protected health information. And so if you disclose protected health information, that's negligence per se. I don't have to prove that there was a standard because you violated a law. Okay? So that's what negligence per se is. The other torts that come into play with psychiatric patients, so I was going to say, with the negligence, in the physical medicine field, if a doctor operates on the wrong body part or we make a misdiagnosis, it's a little cleaner, it's a little more concrete with medical negligence claims. It becomes more difficult in the mental health field. Why do you think that is? Why do you think it would be hard to sue somebody for a misdiagnosis in mental health, or sue somebody for negligence in mental health?
There's not exactly a blood test for depression.
Okay, there's not exactly a blood test.
You can't clearly say this person is definitely depressed to this degree, because it could change minute to minute.
Mm-hmm.
Well, you can say, oh, that hip is definitely broken.
Right.
A lot of that's subjective data.
There's a lot more subjective data and gray areas in mental health. And you could get 4 different doctors' opinions on one patient, and they would all have a different opinion. They did some research where they would show psychiatrist interviews of patients, 50 psychiatrists I think it was, and there was 38 different diagnoses that got labeled for that patient. So it becomes a very difficult field to establish some standards in. It's not that they're not out there, but it's a more difficult field. Typically what you're going to find if you're getting into negligence claims is where there's a completed suicide and the families are suing because we brought our loved one to you and you guys said you would take care of our loved one, and then look what happened. I had a friend that was trying a case, and what happened was the patient went to the primary doctor, said, I'm feeling, I can't take this anymore, I'm feeling really bad, I know I have a brain tumor, I'm going to kill myself. The doctor had put him on some antidepressants the week before, and he said, John, I think you need to go in the hospital. So he called his wife came to the doctor's office, or no, that's not what happened. He wanted to send him by ambulance. He says, well, I don't want that, I want he goes, I don't want 2 cars out. He goes, I'll drive home, my wife can drive me to the hospital. So don't shake your heads. So the doctor said, well, will you contract with me for your safety, blah, blah, blah. He called the wife agreed, he agreed, so they all agreed to this plan. So he drove himself home, he got to see his wife, They got in the car, they went to the emergency room. The doctor, the primary, called the emergency room doctor and said, hey, you know, you've got a guy coming, I'm very concerned, he seems suicidal to me. Please, you know, evaluate him appropriately. And so they get there, he gets evaluated, the ER doctor says yes, he says, I think he needs to stay here. They get him up on the unit. And they're at a level on the unit, like there's levels 1, 2, 3. So level 1, you're supposed to be on for 24 hours, which means you don't leave the unit. Level 2, you could leave the unit for test, and level 3, you can go out on a walk accompanied by staff. So he comes in, the next morning at 9 o'clock, you know, so the admitting doctor, you know, puts in the orders and puts in an MRI order. Well, 9 o'clock in the morning, they come to get him from the MRI, and he's on level 1. So the nurse calls the on-call doctor and says, hey, he needs to go for an MRI, can you change his level? So the doctor, not knowing him, changes to level 3. So then that afternoon after lunch, the staff person says, okay, it's time for everybody to go for a walk, looks at the board, says, oh, all level 3s come with me. So he walks outside and he jumps off the parking garage. And so the claim was, you guys violated your own standard. You changed him from a level 1 to a level 3. Which then there was just all this miscommunication. And that's kind of what I do in quality is we look at the systems breakdown. There was a lot of miscommunications going on. The staff hadn't checked in to make sure and verified that this guy was a level 3. This was a float staff from the weekend, didn't know the routine, didn't know how long the guy had been there. They were found not liable. And it was kind of surprising, I think, to everybody that they were found not liable. It's very hard to find liability. But that's the kind of things you would see is where you have a completed suicide, where somebody was misdiagnosed, or not misdiagnosed, but somehow that person got out of the staff's control.
So, sorry, just to clarify, so like another example of negligence would be a completed suicide. They go into the right floor, they have the right, you know, the right facilities, but the someone leaves a rope in the room. So
Right.
That's negligence. There's a known risk, there's a known chance, and you don't do everything that you can to stop that risk from happening. But malpractice would be the doctor saying, oh, they said they were suicidal, I don't think they're suicidal, I'm not going to implement anything.
Okay, so that's a good question. Negligence it would be for people, if I said they were not liable for negligence, I meant malpractice. So negligence is for the everyday public person. Malpractice comes with the professional. So as the hospital, you know, it's specialized skill of the staff and the hospital to provide services to prevent a suicide. So they're both malpractice. Malpractice is where you have professional negligence. So that would include the nursing and providers and hospitals get in on that too.
So all those examples would be
Right.
malpractice.
Those would all be malpractice.
And that's what we buy insurance for.
That's what you would buy insurance if you bought it.
Why do doctors and kind of, some people have malpractice insurance and like nurses don't?
Okay, let's be honest, but it's a good question.
Well, like individually.
It's an excellent question, actually. What malpractice insurance does is it's the same thing that car insurance does, is it protects your your financial assets. So why don't most nurses carry malpractice insurance? Most nurses are employed by an employer. And so basically, in legal terms, the employer is responsible for your actions. And so that's why if the hospital sued, you're covered because they're responsible for your actions. If they think that you're a negligent nurse and they keep you on, they're the one that's negligent. So I've heard rumors that, you know, the hospitals would turn around and sue the nurses for doing whatever. And that really wouldn't happen, or it hasn't happened. So do you need malpractice insurance? If you are practicing within your role, under your employer's umbrella, you would not really need malpractice insurance. If you go up and set up your own clinic and you're doing some work out in the clinic, if you're doing health coaching or health education, then you would need to have malpractice insurance. There's the Good Samaritan laws, which say if you stop and rescue and something goes wrong and they want to sue you, again, they can sue you. That doesn't mean you're going to be liable. Anybody can sue. But you would use the Good Samaritan law, which says if you are a health professional and you were trying to rescue somebody, you can't be found liable if something goes wrong in that particular rescue. And the other thing with Good Samaritan laws that you need to know about is in Minnesota, you're required to offer assistance. In some states, it's not optional, but the law is there if you choose to offer assistance. But Minnesota legislature said, we want our health people to offer assistance. So as a nurse, if you are driving and see a car accident, you're required to stop and offer assistance.
I thought that requirement was covered just calling 911. Is what an attorney told me in a different nursing class was the requirement to help is within your scope and is within your feeling of safety. And if
It's
you don't
within
feel
your
safe
feeling of
pulling
safety,
over,
right?
you can just call 911 and you're covered.
Well, that would be his or her opinion. It depends on the scope. If it's a clear day and you're not in danger and it would be easy for you to stop and help, then somebody could argue this person didn't stop and help. That's where the gray area of law comes.
I always find that interesting because even if it was a clear day and whatever, I might not feel safe, who knows?
Right.
Another car could see it and go careening into me, so.
Right. You have to
Interesting.
decide if you're gonna be safe or not. It's just, it gets to be how the law is interpreted, and that's why case law builds what happens in the civil court.
How would anyone ever find themselves being sued for like not stopping?
Well, it would be hard to find that person.
Right?
It would be hard to find that person. There's actually a case that I knew about where it was a group of physicians, and there was a group of physicians at dinner. Everybody knew it was a group of physicians. Somebody was choking. Nobody offered to help. In the restaurant, all they had to do was the Heimlich. The person died. The family sued, and he was found not guilty because this was a state that did not require you to offer assistance. And he had no duty. And if you go back to negligence, you have to have a duty to that person. If I'm out eating dinner in a restaurant, do I have a duty to that person? If I'm a doctor, I'm off duty. I don't have a relationship. And that's what the courts found, which is why Minnesota passed a law that said, if you are a health professional, you have a duty to attempt to rescue if it's a safe situation. So let's say it's a nurses convention, and you guys are out there and you're talking about being nurses and somebody starts doing the Heimlich and you don't offer assistance and somebody finds out that you're a nurse and you're there, you might not be found liable. It's all going to depend on the jury. But they're going to present, this is the law, this is why we enacted the law. Is there any harm to you and danger to you to do the Heimlich? That's going to be up for a jury to decide.
Can I ask a
There's one in the back, I'll come back to you.
I'm assuming that does not apply to you if you're a health professional out in the public and you're having drinks. Are you still required to
If you're having drinks,
someone?
Like if you're at a bar.
Like
and
if
well, if you're impaired, again, this is the kind of fun stuff they put on law school exams, because you have to figure out, okay, what if you're impaired or not? I can't say one way or the other, because the law,
If you helped,
And
something
you were
went
impaired,
wrong, and then you work on.
if you helped, okay, anytime and we're gonna get off, this isn't about law, but anytime you attempt to rescue, you have to attempt it according to the standard of care, okay? So if you attempt to rescue, like that if you suspect a neck fracture, you move the person in log roll and you keep the neck, okay? If you go in and you attempt to rescue and you don't use the standard of care of what your knowledge base is, you could be liable. So you have to rescue in the manner that you are trained and know you can do that. So as far as alcohol, that creates a whole nother story. And again, it's what would happen in a lawsuit would be, here's the law, the jury is told what the law is. The law is that nurses or doctors have to offer assistance if they have the capabilities and they're not in danger. They're given the law. And that is an instruction by the judge. And then they hear the plaintiff's side and they hear the defendant's side. And then there's an expert for both sides. And you can always find an expert to argue that that side's the correct side. And so then the jury has to sit there and decide who's liable. Is the nurse liable or not? And alcohol would be a part of that, but the law doesn't say if you're inebriated, you're released from the law. Okay? So it's one of those, it really just depends. Now, I think the other area that you get into is what would you do in terms of your ethics? How good would you feel if you sat there and didn't do anything? You know, I've been in a restaurant where the lady started having a seizure and I went, okay, and I helped her down on the floor and then she wasn't breathing. And I thought, I mean, I've already started to help her. I can't stop. And, you know, I opened up her airway and she started breathing. And, you know, I told them to call 911 and they called 911. But I couldn't just sit there and keep eating, seeing this person get into trouble. So I think the ethics becomes, a bigger issue. The whole purpose of Good Samaritan laws is so that people don't have to be concerned about the liability for if they attempt to rescue and it doesn't go well. If somebody's stopped breathing and they don't have a pulse rate and they don't have a heartbeat and you start doing CPR on them and you quit, can you be sued?
Yeah, because the training for CPR, if you're CPR certified, it says you do it until first responders arrive. Right.
Okay.
Yeah, but what if they don't come for like an hour?
That's
to
one
do
really
CPR?
tired.
You shifts, you should
Right.
tell other people.
So it's a good question, and I kind of like to ask that one because it gets you guys to thinking. You can be sued by anybody. The question is, are you liable? And think about this. The person who doesn't have a pulse and isn't breathing really technically is already dead. So you can't make them any worse off.
By law, they're dead.
No, well,
I mean, like.
let's not get into that argument. The point is, if you don't make somebody worse off, there's no harm. The only thing you can do is make them better. Okay, you're not going to make them any less pulseless or less breathing. So that's the other thing about the law is if you're doing something and you're not harming anybody, remember there's got to be harm for negligence. There's the violation causes harm. So if you have somebody without a pulse and not breathing, you're not causing them harm if you stop because they didn't have that to begin with. It's more tricky if you have somebody that's injured and then you do something and then they quit breathing. But we need to move on because I could talk about this all night. The other torts that you need to think about in terms of mental health and psychiatric patients, false imprisonment is a big one. Can you hold somebody against their will? Can you stop somebody from moving? We know that if a patient wants to go outside and smoke, and we have a policy that's a non-smoking campus, we have a lot of staff that will try to stop them. Okay? That's really false imprisonment because you have no right to stop somebody. Yes, they're violating the standards or you're violating what you want to have done or not done on your campus, but you can't stop. We're not a police station. We're not a prison. We can't stop patients from moving around. Now, what happens in the mental health facility is we have locked wards, so patients can't come and go freely. We have seclusion rooms where we put patients in and they can't leave. Okay, so we start to impinge on that. False imprisonment's a risk, but you would rarely see somebody filing a lawsuit about that. And again, it's because in order to keep somebody against their will, it's a pretty high threshold. And I'm going to talk about what it takes to hold somebody against their will. Assault is the other, the threat. Battery, where you actually touch the patient. Breach of privacy. How is breach of privacy different in the mental health field, do you think, than in regular nursing or physiologic-based healthcare? Is it different?
They're considered out of their right mind.
They're considered out of the right mind. Go ahead, explain. What do you mean by that?
So they're no longer capable of making their own decisions.
So how's that a breach of privacy?
Well, so if you're giving information out to, say, somebody that's in control of their care, that person may say, I don't want them to know, but they're no longer able to make that decision. they're deemed unable to make that decision at that time.
Okay, so like that would be, you mean like a guardianship?
Yeah.
Something like that? Okay. That could be one area, but we also have patients that have Alzheimer's that are on physiologic floor that would occur too. That we would have to be reporting to the guardian or talking to the guardian.
Do you mean as in like privacy as in like space, like they're always being watched? If they're,
It could be.
you could
So
see,
talk more about that.
like they're, yeah, if they're at 20, like if
Right.
they're 1-to-1.
Well,
So-
or in the ED, there are psych rooms that
Mhm.
have cameras,
Right?
that have security cameras that security is watching. So if they claim they're gonna commit suicide and they're also, or that they're homicidal, most of the time they don't put a one-to-one person in the room. They have security on the person outside of the room, and then they have a camera
Mhm.
that security is able to watch.
And which ER is that?
Why?
Huh?
Southeast.
Okay. Well, no, why? Because they're all different.
Oh, okay.
My point is that doesn't happen at all ERs.
St. Cloud has it too.
You know, it just depends on the ERs. You know, so there's those two scenarios where when you have a patient that's in a mental health area, if they're on the floor, they're in a community room and they're sharing things about in the community room. And part of the interaction in the milieu is sharing their information. And so there's really not a lot of privacy. They're telling things about their condition that we don't have patients, you know, we pull the curtain. If we have double rooms, we try to set up areas where we could talk to patients without the other people hearing. We do a lot to keep the privacy, but in a mental health unit, the unit's very open. And you have people going with them to the bathroom. You have people watching them constantly. But they're also sharing this information as part of the milieu. So there is less privacy in this area. I'm not going to talk about defamation. Well, I will. Just defamation, this is slander and libel, and this would be saying something about somebody that's not true. And we do see this in mental health because if you're writing something in the chart and it comes back and it harms that patient, particularly if it gets out, then the hospital or the people who wrote those things or said those things could be liable for defamation if it harms the patient. Now, usually what happens is this comes with HIPAA. So let's say you have a celebrity that's being treated for chemical dependency, and then that information gets out, and somebody's written in there that they're blankety blank alcoholic. I've seen that written in charts. And that gets out, and the guy loses his job. Well, all of a sudden, you're going to be liable, or the hospital's going to be liable for the loss of income and the loss of job and the humiliation and everything else. So the message here is make sure when you're charting objective things, not kind of your opinions or anything that might be construed as negative about this person. So you're being objective about what the patient said, what you observed. You're not making judgments about that person.
How does Minnesota handle the duty to warn?
We'll be getting
conjunction
to
with
that.
Okay.
We're coming to that one.
How does the slander and libel work between patients? Like, are there any laws with that? Because, like, I mean, if you're sharing all that stuff with one another and then you leave the facility and then you start talking about people.
So that's between those two people, okay? So in civil court, you can only control the staff and the hospital. There's a lot of discussion with the patients around, you know, keeping things private. But if a patient goes out and says something, do we have control over that? You know, we really don't. So if a patient says something about another patient and that patient's harmed, then the patient's going to be suing that patient that made that public.
But,
So,
okay.
Go ahead.
No, I'm just wondering, like, if you're in there for, like, a mental illness, can that person argue that they didn't have mental capabilities to
So we're going to talk a little bit about
without
that.
privacy?
We'll talk a little bit about mental capacity, because mental illness does not mean you lack capacity.
Right.
And it doesn't mean you lack decision making. So this is probably a good place to take about a 10-minute break, and we'll get into specific laws related to psychiatric patients.
Can you guys make sure you're back in 10 minutes, because Deb's got a lot of information to cover yet.
We always get distracted with that first part.
Barrage you with all the legal questions ever.
Well, it's really funny because it does depend.
Yeah.
To calm myself.
Oh,
That's what I do.
Yeah, so I'm like,
That makes
Actually keeps me from thinking so much. Like, it's still better.
Yeah.
But you're listening.
Yeah, it takes away enough of your attention that your mind isn't wandering.
I agree.
Here.
Are you busy? Did the baby leave?
Yeah.
So I just wanted to check in with you. How's work?
That's good. Well, it's busy.
I didn't know you were teaching for Mankato.
Yeah.
I know, that's where I got my master's.
Oh, really?
And my BSN.
Okay.
But you're doing
good
out,
quality.
so do you go to
courses online.
Edina?
I
when
go
you
to
teach
Edina
that?
once a month.
Oh, yeah, that's
Yeah.
where I did almost all my master's classes.
That's where all the graduate classes are.
Yeah.
Yeah.
So do you interact at all with any of the faculty?
I do, yeah.
Like, do you know
With the
Dr.
graduate.
Eggenberger?
Oh, yeah, Sandy.
Yeah.
Yeah, I work with all the graduate
She's
faculty.
been a really,
Yeah.
she should be in her office, I think. She's not, if she's not in her office, the only other place I think she would be is one floor down in our nursing.
Okay,
She's
Okay.
probably there.
thank you.
Yeah, Sandy was a big mentor to me on my master's.
Oh, okay, yeah.
And, I mean, I
So-
know everybody.
You know, probably Trish Young
Oh,
and
yeah.
Belle and
Yes.
Marcia Clark, or Marcia
Stevens.
She's retiring. This is her last
Okay.
semester. Donna Brower.
Oh, I know them all.
Yeah.
Yeah.
I
So,
teach with them.
so when you go out, do you have to go out once a week to see the undergraduates?
Every other week.
Every other
It was once a week, but now I made the class half online. So I do every other week, I go down there for
How
those.
do
And
you
then
have time to, you work full-time across the street? and
Yeah.
this?
I just, I'm
Must
busy.
be busy.
Yeah. Yeah.
And the hospital jobs.
But I'm not gonna do both. I'm gonna make a decision after this summer to
Yeah.
kind of see what I wanna do. I like the teaching. You know, it's got more freedom and stuff. The problem is I also like this, but I could still consult with them. And that's what I'll do is just keep the consultation piece.
Sure.
Cause, I've been able to do like some research on falls over there. We got a grant from the Department of Health
Oh, wow.
that we were looking at, doing double staffing during change of shift, because that's when patients were falling.
Yeah.
And we, on this one unit, we decreased fall rate from 2.7 to 0.7.
Wow.
It was really dramatic, and the next day after they quit the pilot, somebody fell. It was just like, I don't want anybody to fall and get hurt, but it kind of showed what they needed to do.
So
I've been doing some
did they double
projects.
staff for like a half hour?
No, for an hour. So
Okay.
what happened was one of the nurse assistants came in an hour early, and they toileted all the patients. So right before they go to bed, so they take them to the bathroom and make sure they had all their needs met. And then in the morning person came in and toileted all the patients because they get their labs and they'd be away. So they take them all to the bathroom. And so I've been doing projects like that, and we're working on a pain project. So it's really
Yeah, there's a lot of variety.
consultation type stuff.
Right.
And so it works nicely with, the quality and safety that I teach.
Yeah.
So it's a good fit.
Sure.
And, but yeah, I'm still gonna do consultation for them. I'm just gonna cut the hours and say, this is, I wanna work on specific projects.
So is your course for Mankato called Quality? What
It's
is it called?
informatics, quality, and patient safety.
Oh, wow.
The
Yeah,
graduate
that was-
level, like right now, I'm teaching advanced patho,
Okay, wow. That would be a challenge for me.
Yeah, well,
I mean,
I've taught it before, but we're so short on staff. We're hiring like 8 new faculty. We're interviewing for 8 positions, actually 9 positions since March is retiring. That's how short of faculty they are. But we need nurse practitioner faculty. So we're using our nurse practitioner faculty in our clinicals. So
Right.
those of us that can teach some of the other courses,
Yeah, the theory.
the theory courses will do that.
Sure.
But yeah, Diane Witt
and Mario's are our two key nurse practitioner
Okay.
faculty. But we're interviewing 4 different faculty now with their interviews, which is good.
Okay.
So, yeah. Good. So, yeah, it keeps me busy. Just,
Well, thanks for doing this for us.
oh, not a
Your
problem. This is
lecture
fun.
is so much more. You can bring in the stories that, that's what the students love.
Yeah.
All the stories you bring up, which is really great.
My dad is a physician, and in the 60s, I forget which state he was in because he was in the Navy then. Was traveling. My mom and he were at supper, and a woman was choking, so we did the Heimlich. In the process, because he did it correctly, cracked a couple of ribs.
Sure.
And she sued him because of whatever state they were in.
Did he lose?
The laws, oh, no. Yeah. She said, I'm going to sue, and he happened to be with his good friend,
Yeah.
who still, years later, was his attorney. He goes, that's great, meet my attorney.
Yeah.
And so in court, they laid out their little sob story, and the judge just kind of said to my dad's attorney, just a moment, please. Okay. He looked at her and he said, so you mean to tell me that this man who's out for a wonderful romantic meal with his new wife, saw that you needed help, asked if you wanted assistance, and you said yes by nodding your head, which you freely admit, saved your life, and which is a normal part of the practice because, believe me, I've had many expert witnesses tell me how the Heimlich works. Cracked a couple of ribs, and you want to sue him because he saved your life. And she said, and her attorney's going, and so he said, okay, we'll move on. Let everything go. And at the end, he said, guess what? You lose.
Was it a bench trial?
Yeah.
Okay.
And he goes, and not only are you going to pay this man's attorney's fees, you're going to pay his dinner tab for that evening. And doctor, how many patients were you supposed to see today when you were supposed to be in practice? You're going to pay for all of that too. So
I didn't mention that if you lose, you might have to pay the other side's attorney fees.
yeah. So it's funny. And then my dad, ever since,
Did she pay
I
all
grew up
that?
in Wisconsin. Yeah, oh yeah, she ended up having to pay. And she did. Or he said, or you can go sit this much time.
Real quick,
Okay.
they were already on the way to preschool.
And so then I grew up in Wisconsin. I then had good school laws, but we'd be in church and I got Catholic in August, and there's old Mr. Johnson being very good Catholic, hasn't eaten anything because he needs to have communion. It's 11 a.m. mass in August, and he's wearing his three-piece suit and his tie. And his baby is kind of going, Dad, Mr. Johnson doesn't look so good. Dr. Tanti's here, he's the ER doc.
Well, I was actually surprised myself because it's very hard. And I don't know. That would be good.
Yeah, sure. I don't know.
It's just how
Right, I don't have like, I don't know what shock you guys. Right. She's shocked. Yeah. Right. So I'll tell her everything about and on top of that, the waist down, you can see the waist up. And driving, and there are all these people, and she says,
Yeah.
and there's nothing I can do. Right.
And 2, we're gonna pay the traffic gas, we have to pull over on 40 highway.
Right.
Yeah, so it's what you said, it's gonna be a danger if you don't. And most of the time you can and more than verbalize that.
Right.
But
That's my dad.
I was actually shocked that was long.
So it's checking all now, I'm like, over the.
Yeah. Accident on the side of the road, she's driving home down to her house, way and
My
it's 10 o'clock.
specialty is
And
French.
I'm kind of by myself.
Thank you, these beautiful.
Yes. Nobody's gonna know your name, that's why we told people not to put our.
Don't get any bandages.
Right.
You know, 'cause you When I was EMT, they said, don't get EMT credits.
And then dump it in the pot, and then
Don't
the.
advertise who you are.
Right.
That's why I also feel like if you're not wearing scrubs on. Wear your scrubs to work, put them on, take them off. First, you don't like wearing your jeans on. But others, you don't want to be out wearing your scrubs.
So nowadays, you want to be a housekeeper.
Well, yeah, that's true too.
Nobody knows stuff to drink, to eat, and then you don't have to go to work, so you just bring it there, you have a court director. Some of them.
Maybe.
I might
Okay, you guys, Jeff's just started.
We're gonna get back. Yeah, we were talking about, do you owe a duty or should you rescue somebody or do you have to do CPR? Do you recall the case at the senior living facility?
Yeah.
The assisted living where the nurse, the patient was at the table, or not patient, it was a resident. It's assisted living. It's not a nursing home, so the resident collapsed at the table and the nurse called 911.
But did not do CPR.
But didn't do CPR, and the 911 operator was really desperate to get somebody to help this woman. And the courts decided she had no duty to do CPR on this patient. She did the duty, which was she called 911 and said, you need to come here. And a lot of people were outraged around the ethics of it. But at any rate, it's a gray area. Some other state might have done something different, and it would be interesting to know if it had been in this state, how that would have been different. Because California does not require nurses or doctors to provide assistance.
But isn't that a safety thing as well? Because if they aspirate and they had something and you were given CPR and you didn't have a mask, or, you know, I mean, isn't that part of our safety too, if you don't feel safe?
Well, again, we're not gonna get into the argument about that. I'm just trying to point out. Right. What I'm trying to point out to you is, in California, they don't have a law that requires you to offer assistance. In this state, we do. It would be interesting to know how this state would have decided the outcome of that case. Okay? And again, whether or not you are feeling threatened and unsafe is a very subjective individual event that you have to keep in mind and that you would just have to prove in court.
So what if, okay, with that instance of the woman that called 911 but didn't do CPR, what if, did the board of nursing do anything about it? No? Because like to me, it's like, why are you a nurse?
Well, that gets back to the
We're
ethics of it.
trained for that, yeah.
Right. That gets back to the ethics of it, but your nursing license is based on laws. There's no law that says you have to, in California, there's no law that says as a nurse you have to provide CPR. You know, this was an assisted living, this was not a nursing home or a hospital. So that's considered like, it would be a nurse that was in your home, like a home health nurse with that nurse. And she wasn't there providing nursing care. She just saw that one of the residents who was eating lunch had collapsed. So she did what she would do, which was to call 911. So again, it's beyond this class, but the point is each state has different laws. And how those laws get interpreted is going to vary. So we could spend all day talking about that one. I'm sorry I brought it up. So let's talk about psychiatric patients in the law. So psychiatric patients face violations of their rights. And the big rights are loss of liberty and freedom, loss of self-determination, loss of privacy. So with the loss of liberty and freedom, most facilities, when a patient goes in a mental health facility, they go into a locked ward. Now there are some hospitals that don't have locked wards. If a patient's voluntarily coming in and they maybe have an eating disorder, or they're depressed but they're not suicidal, or they are an adult survivor of child abuse, there are units that are not locked units. Because taking away their freedom and their liberty is kind of considered maybe a re-abuse of what they've endured. But most of the facilities you're going to see are going to be locked wards. The other thing we do is we deny patients their possessions. They come in, they have a search done, we take away all their possessions, we We give them scrubs sometimes we'll give them back their street clothes. On units where there's a high propensity for violence among the staff, or patients, not staff, patients, they might just have them wearing scrubs. Because we do have some units that have the antisocial behavior, highly violent patients with mental illness, and they only wear scrubs rather than having their own clothes. We also may use restraints or seclusion, which takes away their right to freedom. Now, we're going to talk about restraints and seclusion a little bit, so I won't get into detail, but there are very strict guidelines on how we do restraints and seclusion, and there's two different laws that we have to look at. And one is CMS, which is Centers for Medicare and Medicaid Services, which is a federal law, and the other is the state law. What does our state say about use of seclusion and restraints? So you've got both federal and state laws that you have to keep in mind. The other area is loss of self-determination. So we force detention and we force treatment sometimes. And when we force detention and treatment, that's where we're gonna get into more detail. But patients are always at risk of being forced to stay or forcing treatment. Not all patients are at risk for forcing treatment, but some are. Okay, so loss of privacy is the other. The group environment with the community living, and then others may disclose real threats of imminent danger to an identified, or let me read this again. Others may disclose real threats of imminent danger to either others or self. So they might say, and what I mean by identified others is not, I'm going to go out and kill a mass of people, but I'm going to go out and kill Mr. Smith or Mr. Jones. So there's this loss of privacy. If a patient discloses to you that I'm going to harm myself or I'm going to go harm somebody else, you have an obligation to report that. You have an obligation to intervene and do something about that. So I want to talk about just kind of hop back to the legal system, the due process. If I'm out in the world and I don't have mental illness and I do something where my rights are going to be violated, the court system has to submit a warrant. So it's either a warrant for arrest, a warrant for search and seizure, or a warrant for my life. So in states that have the death penalty, there's a warrant that's issued for the person's death. Otherwise, the warrant for search and seizure, if I want to go into somebody's house, or if I want to search a person, I have to get a court order for that. If I want to arrest somebody, if I want to detain them and take away their rights, I have to get an arrest or a warrant for that. The other due process piece is the right to speedy trial and hearing. Okay, so if I'm a person out walking around the community, I have these rights. One of the things that happens with the due process is the legal system allows some temporary detention and limited searches. So if I'm engaged in an activity and a policeman sees it and thinks, okay, you're engaged in illegal activity, they can stop me and detain me, and they can search me. And they can search me just so that they're not in danger. So they can search me minimally to look for weapons. They can't do a complete search of my body. And the detention requires a Miranda rights, where you have to be told why you're being detained. So if you walk up, or a police officer walks up to you and starts asking you questions, you can turn around and walk away. You don't have to answer their questions. You don't have to cooperate with them. Most people won't, because they know, oh, this is a police officer, he has authority, and I'm going to stop and talk to him. In healthcare, we have a similar due process exception. And this exception is that the court allows us to detain patients for a maximum of 72 hours. Okay? So when we put somebody on a 72-hour hold, it's an exception to our rights to freedom. The threat, there has to be a threat of imminent danger to self or others. So if I mentioned that, well, I'm going to go shoot myself, and I don't have a gun, and it's a weekend, I can't buy a gun, and there's a bunch of other stuff going on, is that an imminent threat to self? Well, it's going to be a great decision, but it has to be an imminent danger to self or others for it to rise to the threshold for a 72-hour hold.
I feel like I've heard people talk about this, but can it be more than 72 hours if it happens on a weekend? Then do the weekends not count as
The
days?
weekends don't count, and we're gonna get into each of these. So I'm gonna get into these in a little more detail. A hearing is required to extend the detention. So it doesn't count for weekends, but let's say somebody came in on Friday, we put them on a 72-hour hold. So it starts the clock, but then it goes to Monday, it goes to Monday and Tuesday, so the weekends don't count. It's not for medical holds. You can't hold the patient because you want to give them antibiotics or get a chest x-ray. It's only for psychiatric holds, which means it's that threat of harm to self or others. Yes.
Let's say you had a patient come in and they would say they wanted to kill Jay, the next door neighbor.
Mhm.
And then after that, they were gonna kill themselves. Besides charting that, how does it go, who would I tell? I mean, I'd tell my charge nurse, and would that be, that would be how I would stop, or do I need to tell the legal department, or who else do I tell?
You would tell, if the patient's inpatient, you would tell your charge nurse, and you'd also tell the providers that the patient is making this threat to harm. Now, the charge nurse might tell the providers.
Okay.
So you need to look at what's the procedures within your facility for reporting that.
And when you're hired, they go through all of that legality
Right.
part of it?
Yeah, they'll tell you what the process is. Most of the time, these patients are gonna be, all patients that have a hold have to be evaluated by a trained provider who knows how to do this assessment to determine whether or not this patient's imminent dangerous. We had a case where a patient had talked about harming himself, and the staff were concerned. It was outpatient in a clinic, and the staff called the social worker who was skilled at doing these interviews and determining whether or not this patient could be admitted involuntarily. And the patient didn't want to go over and get evaluated at the emergency room, but he agreed that he would go the next morning, and his mother was with him. And so the social worker decided it was not imminent danger. He was willing to verbally contract and go over and be seen the next day. And the next day, when they were getting in the car to go to the clinic, he jumped from the parking garage. So you have people who are trained to discern whether or not that person is imminently dangerous. But what the staff did at the clinic was they contacted the person who has the skill set to come in and interview and do that. So that would be kind of the umbrella rule, is who can you contact to then make that determination. In the hospitals, when we have patients that maybe have dementia, or we have questions about their ability to make decisions for themselves, we usually call the physician, and that physician will come in and either do an evaluation or get a psychiatrist or a trained social worker who will do the evaluation to see, is this patient somebody that we can hold. So your job is to help get that person into the system or connected so that somebody can come do the evaluation. You're not ever put in the position of you having to do that. So that was just a kind of an overview, and I'm going to get into the details of the due process. But I just wanted you to see that in the legal system, there is due process. So if we think has violated something, they have due process. If somebody's in our healthcare system, they also have due process, and we have to make sure their rights are upheld. Now, there's two types of hospitalization when it comes to psychiatric mental health patients. One is voluntary, and that's where the patient comes in, patient seeking treatment. They have the right to demand and obtain a release. So if a patient comes into the hospital and says, I'm not feeling really good, I'm feeling a little suicidal, I'm really depressed, I'm not sure if I'm going to hurt myself, they come in, they get into the facility, and sometimes they kind of panic. They're not sure what to expect. They walk in, the door shuts behind them, they're asked to take off their clothes, somebody goes through all their belongings, they get into the facility, they walk in, they see other patients, and they start to feel less safe because they're like, I'm not sure if those patients could hurt me or not. I'm not sure if I'm going to be safe. And so then they say, I want out. Okay, so then what do you do? Because they came in voluntarily. Well, many facilities have a policy that they have to stay at least until they get evaluated. If they're really pushing to go out, somebody can evaluate them. And if they really want to go, we let them go. But most of the time, you can get the patient to stay until they get their evaluation. However, If the staff are really concerned and the patient's pushing to leave, then we could go ahead and do the 72-hour hold, and so that patient gets changed to an involuntary admission. And that's always a tricky thing to do, because if somebody's coming in for help, you don't want to take their rights away because they're coming to you for help, and then all of a sudden we're going to make them feel like a prisoner. So it's always a tricky thing to do. The key is somebody comes in and assess their risk for harm. So you can come in voluntary, it can be switched to involuntary. The other type is an involuntary admission. And with the involuntary admission, there's a 72-hour hold until there's a commitment hearing, okay? And the commitment is that you can detain that person without their consent. So it's imminently dangerous to self, imminently dangerous to others, or if they're unable to meet the basic needs as a result of their psychiatric condition. And that's what I talked about before, where they can't get food, shelter, water, can't take care of themselves, then that person could also be somebody that you could detain.
Why
Yes.
doesn't this happen more often when people refuse necessary medical procedures or treatment? Because that's part of the Minnesota definition,
Why doesn't what happen?
involuntary commitment. So someone who's massively, or has major depression, they refuse to get medically necessary treatment. That's within their right to do that, but that also qualifies them as mentally ill.
Well, that's a fine line. I mean, they have to be so mentally ill that they actually can't take care of themselves. It's a very high threshold to take away somebody's rights. It's not illegal to be mentally ill.
No, but I mean that was part of it, was that, you know, medical
Necessity?
necessity was on the same level as food, water, clothing, you know.
Right. But who determines medical necessity? I mean, just because somebody's depressed doesn't mean just because you're depressed doesn't mean it's a medical necessity for care.
No, but I meant like if they're depressed and they're refusing their antibiotics for
Right.
something.
You can't force anybody to take medications against the will. As long as they have decision-making capacity, you can't take away their rights. We have a right to refuse medical care. We had a patient that was, she was over 700 pounds and she was in bed and she couldn't get up. And we had her in the facility. She had really bad lymphedema. She had congestive heart failure. We were trying to help her out and she kept refusing to take her meds and refusing care. And the staff said, we don't know what to do with her. And she said, I want to go home. Because, the only thing we could really control was food. We gave her healthy food, but she wanted other, chips and stuff. So we did an ethics consult. And we said, do we send this person home? If we send her home, she's going to die. And so the first thing they did was they had a psychiatrist come in to determine, does she have the right to make decisions for herself? Does she lack capacity? She doesn't lack capacity. She can make decisions for herself. We have a right to make bad decisions, and that's part of what we do as Americans, is we have those rights. So we decided she can go home. And, they came in, this is a patient that the fire department has to take her home. They have a big bed. They get her home. She didn't wear a BiPAP that night. She died. It's a horrible case. It's an ethical dilemma, but from a legal perspective, she had a right to make the decision to go home and refuse care. So it's tough. This is a tough area to be in when you're looking at, okay, if somebody's depressed, are they making good decisions? We're going to get to forced medications. It's hard. Let me go to him and then.
It sounds like danger to self is where a person takes an action that's harmful as opposed to refuses to take an action that's
right. Harm to self means I'm going to do this imminently. Like, if you don't do something now, I'm jumping. If you don't do something now, I'm pulling the trigger. I'm going out and running the car off the cliff. Not taking care of myself can be ultimately dangerous to me, but I'm not actively necessarily doing. I mean, if you think about health, it's the slowest way in which we die. I mean, any of us could be accused of committing suicide if we're eating high fatty foods and not taking care of ourselves. So where do you draw that line? And that's where the key word is imminent. Somebody is imminently actively doing something. You're taking steps to do something. I went out and I bought a gun. I put a will together. I made provisions for my dog and my kids. That person is highly dangerous, an imminently dangerous person, and that person would be in a 72-hour hold.
Deb, can you just explain to the students who can order the hold?
Yeah, I'm gonna get to the hold in a minute.
Or I mean, who can put it, who the providers are that can, order a 72-hour hold?
Well, a physician has to order a
Right.
72-hour
That's
hold.
what I wanted. I just
Yeah.
wanted them to know that a nurse can't do that.
No, a nurse can't do it. The nurse says, I have concerns, and that's why I'm saying the doctor has to come evaluate. And sometimes it could be a psychiatric mental health nurse practitioner, but a physician has to write the order for the hold, and I'm gonna go through the whole process.
Really quick, on the flip side, do people who experience homelessness ever use this as a way to get 72 hours of some care and warm and
I think there are some people that are identified as malingerers that might come in and say, oh, I'm, so forth. I don't see that a lot. Most people don't want to be locked up.
Yeah.
I had a guy that was in the hospital for he had pneumonia. He was a homeless guy. He had schizophrenia. He lived in Alaska. It was winter. He'd come in with pneumonia and he'd do like a couple days and then he wanted to leave. And the staff are like, we can't let him leave. And I'm like, you can't put him on a hold. You can't use handcuffs. He has to be able to leave. And they're like, well, he's dangerous to himself. Well, he's not imminently dangerous to himself. Yes, if he doesn't get his if he doesn't get his pneumonia treated, that could harm him. But if I have somebody that doesn't have schizophrenia, I'm not going to hold them. I mean, mental illness in and of itself is not a reason to deny people their freedom. So, how do you deal with that? He liked coffee. So I said, if he goes out and sights and smokes, say, here's a cup of hot coffee. Will you be back before it gets cold? He'd go smoke, come back, finish his coffee. After 5 days, he got his treatment. He was done. He didn't come back again. But I was talking to him, and I said, so where do you live? And he's like, lives at the shelter. And I said, well, do you like it there? And he said, well, yeah. And I said, why do you like it there? He says, because people leave me alone, and they're like me. And he liked being homeless. People left him alone. Most people with mental illness, particularly some of the homeless and the schizophrenic, they're more scared of you, and you're more dangerous to them than they are to the rest of the world. So I would say my experience has been is there may be somebody, but I think most people are not going to do that, that they really value their freedom. I don't know, Laura, if you've had a different experience?
No,
or?
I agree with you. I mean, I think that there are a few, but I don't think very many.
Because, you do get your rights taken care of. You're told when you get up and what you eat and when you go to bed and, what you can do.
I wonder, how much, kind of more to your question about why we don't do this more often, how often these are more damaging than helpful. Like for some people, people who are kind of borderline, they got major depression, but they're not suicidal, now they're and they get involuntarily hospitalized.
Well, you're not going to get involuntary. The only time you really
get
don't.
through this process, and it's very traumatic.
Well, a 72-hour hold, again, only if you're imminently dangerous to self or others.
But there's times when people go and they're admitted and they're
Right.
starting the process. Even that would be very.
Right. Starting the process is very scary to people. And when they realize this is a law board, they start to think about that. And that's why they really try not to turn somebody from voluntary into involuntary. It's mostly, let's get you acclimated, let's do some other things. So, and that's what you'll see with the staff. Once you get out there and really observe the staff, how they interact with patients and how they handle these patients. It is a very rare occasion that you'll see people on 72-hour holds. Now, you'll see more of them in the side facilities than you will in other areas. But it is, it's something they really try to rarely do. Somebody else have a question, or we can move on? What time did we get out?
Well, we actually, you can,
So,
we're in class until 9.
okay, well, I think we can get a pretty good distance here. So 72-hour holds, Again, it must be an overt act, attempt, or threat of harm to self or others. It's 72 hours exclusive of weekends and legal holidays. So we had a patient one time that was like 10 o'clock on a Friday night and was gonna leave, and we got a 72-hour hold. The clock really didn't start ticking until the next Tuesday. You know, because you know, it was Saturday, Sunday, Monday. So really the 72 hours started on Tuesday. Now, one of the things you can't do is a consecutive 72-hour hold. That 72-hour hold triggers a commitment hearing, and you have 72 hours to get that patient into a commitment process. And if you don't make it, you have to let them go. So you can't turn around and say, okay, we're going to put another 72-hour hold on. In this process, patients must be read their rights, and that includes the right to an attorney. Now, who reads them that rights varies from facility to facility. A lot of facilities I've been to, it's the social worker. At some facilities, it might be the nurse. At some facilities, it's the physician. But somebody has to read them their rights and say, you're being put on a 72-hour hold. We're putting you on this hold because we are concerned about your safety and or the safety of others. We'll do this for an evaluation, and they go through the process. There'll be a hearing. They talk about the hearing. They talk about the right to an attorney.
Does the patient have the right to go to that kind of hearing? Or do most of them go, or?
No, they'll go. Sometimes they, you know, will take patients down at Regions. When I was there, they had actually a room in the basement because they had so many commitment hearings there that the judge would actually come there, and they had a metal detector and everybody that went into the hearing room.
If they medically couldn't go, the judge would come to them then?
Well, most people in on a psychiatric 72-hour hold, those patients are physically okay to go. Now, there are some patients, inpatient, that let's say there was a suicide attempt and they're in the ICU and they're on a 72-hour hold. They could have a representative go. There are other ways that can be handled, but for the most part, I'm talking about these patients that are up and about, that they will actually go to their hearing. There are some patients that they're on the patients and they can go to the courthouse. But because of the volume at Regions, they just put a room there. So we'll do it down there. Let's see what else. So the patient, the other thing is the patient may start out on a 72-hour hold, and in the process of that hold, gain some insight into what their behaviors are, maybe talk with the staff, and decide, you know what, I'm going to agree to voluntary treatment. And that hold would then stop. So they don't go through the entire process because the process starts a commitment hearing. Okay, it's not just we're putting somebody on 72 hours hold so we can provide them care. It's that we're really starting to commit them and hold them against their will. So they can start out as 72-hour hold and agree to voluntary. The one patient I talked about that that jumped from the garage, I think I've talked about two of those, but the last one, his mother was concerned about him, and she called the police, and he was in the hospital for 72-hour hold. And he was doing okay, he was evaluated, and they thought he was going to be safe. And then he went to a different facility to seek treatment. Actually, it was a different facility, it was a clinic, and the clinic was concerned about him. Well, the clinic didn't have medical records that communicated with the medical records at the hospital. And so the clinic staff didn't know about his history and that he had been picked up for 72-hour hold. Had this person doing the assessment known that, he probably would not have agreed to let him go home and come back the next day. That's something to keep in mind, that when you have somebody with a 70, I just kind of triggered my mind about, it's a very complicated process with these holds. In Minnesota, there are really 6 types of commitments. So the 72-hour hold triggers a commitment hearing, and there's 6 types of commitments. There's the mentally ill person, and this is a person that as a result of their mental illness poses danger to self or others. There's the mentally retarded person, and this is the language that's in the legislature. As a result of mental retardation or developmental delay poses a danger to self or others. And again, these are intimate dangers. There's the chemically dependent person that as a result of their chemical dependency is unable to manage their personal affairs and poses a danger to self or others. Then there's the persons who are mentally ill and dangerous to the public. So as a result of their mental illness have caused or intended to cause serious physical harm to another and are likely to take such action in the future. And these are some patients who maybe have been in the system. They're the antisocial behavior or personality disorder. They're patients that are going to be dangerous to the public. Then we have the sexual psychopathic personality. And these persons, and this is the words from the legislature, have utter lack of power to control their sexual impulses as a result of a mental disorder and therefore pose a danger to the public. Then there's a sexually dangerous person who has a mental disorder, who have engaged in or are likely to continue to engage in harmful sexual conduct. And Minnesota is the only state that has indefinite commitment. And it's for these, the sexual psychopathic personality and sexually dangerous person. So what that means is they can be committed, if, let's say the patient, or let's say the person was arrested for rape and they served 20 years in prison. And after 20 years in prison, they get to go free. If you are civilly committed as a sexually dangerous person, you could be in a civil committed in a psych mental health facility for the rest of your life. So the stakes get very high in Minnesota. Now I'm going to show you a slide where in October, people started questioning this. And a couple years ago, the first person was released from that program. And they've kind of been watching, there's a second. And now there's a constitutional challenge to this law because we've taken away a person's rights indefinitely. And the question is, can you do that, even if they are this sexually dangerous person?
They're mostly housed at St. Peter, right?
Yes, most of them are housed at St. Peter. Wow, this looks better on the screen than on mine. I just want to show you that this is the process. This is why 72-hour holds are pretty, you know, we use them judiciously, if you will. So if somebody comes in voluntarily, they're undergoing treatment and they're discharged when the patient and doctor believe it's appropriate for their discharge. If we put a 72-hour hold on somebody, there's this pre-petition screening. So it's an actual court document that has to be filed to put a person on a 72-hour hold. So basically what happens is if you're a nurse and you're concerned, you let the provider know. A provider comes in and checks this person and screens them to see if they're dangerous to themselves or others. I was a clinical nurse specialist at United Hospital, and the nursing staff called me and they said, John Smith wants to go home and we think he's dangerous and the guy is yelling and he's screaming and he needs to stay here for care. And I said, well, you call, I can't remember the doctor's name, but the medical director. I said, you call the medical director and have him come over, I'll stay with the patient. And so this guy's in the room and he's yelling and he's screaming, he's throwing the phone, and I'm just sitting there and he's like, it's your fault I'm getting a divorce. And this is a medical unit. So we're trying to decide, can we keep this guy? And so the doctor finally comes in and he talks to him and he does his screening and he says, we got to let him go. He's not imminently danger to himself or others. And so there's this pre-petition screening, and that's what he did. He dismissed this and discharged the patient because we had no reason to keep him. And again, that's a provider judgment. If he says, yeah, we think you might be dangerous to yourself or somebody else, then it's a probable court hold. So the courts are granting the healthcare provider, the healthcare system, the right to hold this person for 72 hours. And there's a document, and it gets written out, and then the patients are read their rights, and then there's a pretrial. So that's this hearing where at the hearing, these things can happen. It can be dismissed and discharged. The judge will go over the documents and look and see, does this meet the criteria for 72-hour hold? Up in Alaska, they were putting 72-hour holds on everybody. And when the magistrates would get them, they would just call up and say, let the guy go. It was kind of like you can't just hold people against their will. So the problem with that was, then when we really had to hold somebody, they probably weren't paying as much attention as we needed them to. The hearing could be continued. So the judge may say, I don't have enough, we're going to go ahead and continue the hearing, which means we need more time. And so the patient stays in the hospital. It can continue and remain on hold, or they can admit the petition. So what that means is this person, at the pretrial, we could say that this person's so dangerous. Let's say there's somebody that's a repeat person that sexually offends. That judge may say, we can just go ahead and vet the petition, and that person gets committed to Anoka or St. Paul. More likely what happens is this is continued, and then the patient's examined. And the patient gets an examination by their psychiatrist, by the court psychiatrist, and probably the psychiatrist at the facility. So we get all these opinions. So then, after the examination, it could be dismissed again. It could be confined or continue to a final hearing. It could also be an admission. So we admit the patient and we commit them. At the final hearing, they can decide to dismiss it. They could stay a warrant of commitment, which means that they're going to put it on hold. The patient can stay in treatment, and the judge can say, we're going to keep you in treatment, but we're not going to commit you. We're going to come back in 3 months, or we're going to come back in 6 months. So that's what we mean by that. Or they could say, yes, you're committed to these facilities. So what happens when a 72-hour hold is initiated is it triggers this whole process. Most of them get dismissed and discharged, or we go to trial and they get into this examination process. It takes a long time once they get past that 72-hour hold. 72-hour hold means you get to the hearing. It doesn't mean you go through this whole process. You have 72 hours to get to this position, okay? And then what can happen is usually there's a 30-day time where we're going to observe your behaviors, we're going to interact with you, and we're going to collect more information about your insight. Does that make sense? So 72-hour holds is just until we can determine how dangerous you are.
What about people's rights with a speedy trial? Like,
Well,
after that 72 hours is over, I mean, if that takes 30 days, that doesn't, like,
a lot of times this commitment process can be done in like 30 days. You know, it might take longer because you want more information. But if you think about other trials, it could be 2 years out before you go to trial. So this is actually a pretty speedy process. If you're in the criminal justice system, the criminal justice system can take a long time. So this is actually pretty speedy.
This is for a commitment, not a 72-hour hold. The 72-hour
Right.
hold.
This is the 72-hour hold
Okay, yeah.
where somebody says, I think we need to keep this person. The doctor makes a judgment and says, yeah, we can keep them or not.
Okay.
And if we keep them, then it gets into the court system.
Thank you.
And then the judge is making the decision about whether that person is committed.
I do have one quick question. So let's say they go through the process, they get to exam, and it's determined that they can be dismissed and discharged.
Mhm.
On their way out, good, I'm gonna go kill so-and-so now. And you said there can't be consecutive 72-hour holds. How does that?
You've got a screening, you've got a hearing in here.
Yeah.
And so once this is done, this wouldn't be a consecutive 72-hour hold.
Okay, I see what you're saying. You
You've
can't
completed this
partially
process.
stop the 72 and then
Right.
start it. Okay.
Once the 72-hour hold, once you get into this part, the hold is off. I mean, the hold might be this part, a probate court hold.
Sure.
So at this point, it's the court that's holding the patient,
No.
not really our facility. Because we don't want that.
So during that hold, they are in lockup.
They're in a locked ward usually.
Or whatever they are,
Right.
somewhere locked up.
They're usually in a locked ward. Now, there are some patients on a physical unit, med-surg unit or an ICU, where they're on a 72-hour hold, and they will have somebody assigned to them, a 1-to-1, or they may have a security officer, but there could be somebody with them, so they're out in the unit, but they're physiologically not stable enough to be on a mental health unit. These are great questions. Who can do the process? Who can start that? Hospitals can do it. Family can do it. And basically, what happens is the petitioner sends this petition to court, and that's that pre-petition team that investigates. As I mentioned, the mother of the one patient called the police and said, "I'm concerned about my son." And so what she did was she evoked the criminal justice system, the cops or the police, to go out and do a welfare check because she was that concerned. And when the police went and they talked to him, they decided, yes, he needs to be in the hospital. So the mother initiated that. She didn't actually file a petition, but she at least got the police involved because they're the ones that can get them there. There are times where parents have had to ask for their sons or daughters to be committed. There was a recent case with a son that was at school that was threatening to kill people. And the mother called and turned her son in because she didn't want anybody harmed. So she filed a commitment. There's a real tension right now with parents, and particularly parents of aging or adult children with mental illness. And they're violent and they don't know how to handle them, but they're their son or daughter. And it creates a horrible situation. So they don't want to commit them, but they don't know how to handle them. And so we have some issues in our society about how do we work with people. We don't have the resources. We don't treat mental illness like we treat other diseases. If I had a spinal cord injury, my insurance is going to pay for my rehab, for the time I'm in the hospital, for my surgery, all the way through rehab. If I have depression or post-traumatic stress disorder, I get 10 visits a year. And that's not going to necessarily help my brain heal. And you think about it, it's the same nervous system that needs to heal.
I have a quick question about individuals with eating disorders.
Mm-hmm.
I know somebody who's working with a patient who did home care, and she was put in the hospital on an involuntary hold because her weight dropped to a certain point. Like, is that a legal? Is that like a contract with your doctor, or like, I don't know, how does that work? Do you follow what I'm saying?
I think I do. It might be that if the weight was so low, my guess is what it is that goes back to that person's not eating, and because they're not eating, they're in imminent danger. And so that allows them to do the 72-hour hold to go through. I don't know if that's the hold you're talking about, but that's the only kind of way that a healthcare system or healthcare people can keep people against their will, is if we have that hold in place.
But there wouldn't be something that would be set up as if, like, if you get down to 71 pounds,
No.
you have to, okay.
No.
But that's, it was more to do with other things.
No.
What if they're a minor? Did I just open up?
No, you didn't open up again. I mean, I'm not a juvenile, but there are certain rules around minors, and it gets into parents have to agree to the treatment for the minors. The tension comes with minors and more where the parents are seeking treatment and the kids are not wanting the treatment, and the parents are saying, yes, you can give them this treatment, because until they're of age, parents can agree to treatment. And so that's where we get kind of the tension in that area. There's also, I just want to go over that, let's say if that 72-hour hold is initiated and it's denied, let's say I'm a family member and I say this person's dangerous, and we go to a court hearing and the judge says, no, I don't think this person's dangerous, I'm denying the petition for commitment, it can be appealed to the county attorney. And so that gets to, we still think this person's dangerous, we think the judge made a mistake, it gets appealed to the county attorney. If it's accepted, if the petition's accepted, it goes to the county attorney's civil commitment unit, and the county attorney is the one that goes to the pretrial hearing, and then that's where the attorney for the person who's being committed shows up. I'm not going to go through this process too much. I'll just hit the highlights. There's the preliminary. Then the thing you have to keep in mind about a commitment process is it is a judicial process. It has nothing to do with the healthcare system at this point. So it's all within the legal system. And I've talked about the different outcomes for that. Patients are committed to public or private hospitals. It's St. Peter is where the hospital is that most of our patients go, but it's pretty booked up and filled. So Anoka Metro Regional Treatment is a backup, and it's also pretty filled. Initial commitments, if we go through the whole process and the person's committed, they're committed only for 6 months. And then after 6 months, there's an evaluation. And that involves another full hearing. Okay, so to commit somebody doesn't take a long time, but it's a big process. After 6 months and after another full hearing, if that person is committed, they're committed for 12 months maximum. Okay? There are the 3 people that I talked about, indefinite commitment. And that is the mentally ill and dangerous, the sexually psychopathic personality, and the sexually dangerous person. And this is what's being challenged in our courts. This was just posted back in November, and so Minnesota State, the Senate, is holding hearings about whether or not this is constitutional, because these 698 sex offenders that have been detained indefinitely are filing suits to try to get freedom, because they're saying our law is unconstitutional. So to preempt that, the legislature is looking at, we need to revisit this program because they really don't want, to be found unconstitutional. This was just an example of two people. I'll give you this example and then we'll take another quick break. But there's Eric Eichens. He's never been convicted of a crime. He's 19. He's developmentally disabled. He confessed to sexually molesting at least 6 boys before he turned 14. And on November 7th, a judge committed him to an indefinite term in the sex offender treatment program. So that's the first person. The second person is Thomas Duvall, 58, who admitted to attacking at least 60 women, including a 17-year-old girl he raped while hitting her with a hammer. So he was released from the program. So you've got these really divergent cases that demonstrates really an arbitrary manner in which Minnesota treats rapists, pedophiles, and sex offenders that are deemed to be dangerous in the community. So this is another reason why they're looking at this law is, are we consistently using the law? How do you determine which one's most dangerous? How do you determine who can go out in the community? Thomas Duvall, he doesn't have he's not schizophrenic, he doesn't have developmental delay, he's not mentally retarded, but he is being released. So just things to think about in terms of these commitments of the indefinite commitment. Minnesota is one of the few states that's done it. We were the first state to do it. Most states don't have indefinite commitment because the idea of commitment is you're committed for treatment of your mental illness. It's not intended to be prison or somewhere you go just so that you're kind of held, so that you're not dangerous to others. But we also have what is in the balance is public safety. And that's what Minnesota was looking at when they enacted that law. So let's take a 10-minute break and then we'll finish up.
Is Duvall, he's not in the sex offender program though, he's just in a regular
Right, he was in prison.
Yeah.
Yeah, that's the difference. And if you can't indefinitely, well, if somebody gets life sentences, you could.
Yeah.
But that's a rare.
Okay.
What'd you say?
I bet he got released to the Midway. I got a sex offender notification. I won every 2 weeks from a neighborhood.
Oh, you
There's
must.
so many halfway houses.
You must be east of.
And then,
Oh, you're not.
Between Snelling and Milton.
Oh, really?
But I'm right on University, so I also get everything.
Okay.
There's 4 different halfway houses.
Yeah.
So I know they're actually from residents. I think they're very
Yeah. East of Lexington, there's a lot. Yeah. No, it's a problem in our society.
So what do you do? What's the therapy now?
I'm involved with so I facilitate service events for guys. And then I also work on quality projects with repairs, like the Falls project, Falls. I'm working on Peace project. So that's kind of what I do. So the Falls team, I work with the STAR program to work on improving stroke outcomes, decrease realities and mortality. So I do the process, I help the come up with interventions and and so I came up with an associate saying, hey, I teach the course on informatics quality.
There's so many different ways to measure that.
Wow.
It's becoming less mainstream, like, you can't have that as an initiative because you can't measure it.
No, we find ways to measure things.
Literally, it's everything.
I know, I'm just gonna drive you crazy. Yeah. I could look it up through all my old emails. I know. You did. Where did you move to now? Really? In St. Paul?
Yeah.
Yes, that is his kitchen.
Oh, that's exciting. I mean, you live in old houses before my house, and then you move a lot, so.
I know, that's why, so, it's about 6 blocks from where I used to live, like, either way. And so I'm like, okay, when I went up to the last, I can't deal with this, so I got a job in the workforce. And then I left.
See, and then you can
Where I was
turn it
living.
on.
I said, where do I wanna live?
Do you like give up on your own?
So,
Yeah, because I wasn't gonna be here.
so I'm gonna be
So it's not like an older house?
It's a bungalow, it's a 20 so it's in great shape.
I was gonna say, you have to do a lot of work.
Yeah, it's foundation. Yeah, foundation's good. I have, it's more cosmetic stuff, yes, but like in the basement, you know, a lot of the basements, they're just like, low ceilings, it has a real tall ceiling. And it has still the original beams, it's not been reinforced, so the beams are still there. And, it needs, like, the windows need to be glazed, yeah, because they didn't really, they just didn't keep up. So a lot of the cosmetic. Oh my God, yeah, it's so very fun.
I'm just trying to think. I mean, like, I really know that area.
I'll
Had a good time today, Barry.
I'm just like, there's lots.
4 hours staying on my feet. Just give me a call.
What a wonderful area.
You know, like I moved in, the neighbors are like, it's so funny, I come home at night, I get home late at night,
You can just
they've
show
already
up.
shoveled my sidewalk. And one night I come home,
You've got a bunch of.
and so I thought, I'm just gonna go out and look at so I realized, you know, walking out, and stuff, and then when I was moving in, I was across the street, I got friends all over the yard, and like, are you here? They're like, no, she's in the house. You know, the guy down the street was like yelling at like 3 houses away. Like, did or no. Like there were a lot of houses over the area. And I think people were, were trying to sell, and they just put that out and stuff out there. So I just kept looking to see if it was their house, wasn't ours. And so I was like, one day I was like, his house, and I was just they call me back. And so houses, that was what was hard. Big houses, there wasn't a.
Did you start out by deciding on what neighborhood you wanted?
Yeah,
Or were you kind of looking all over the place?
I picked, like, there were 4 different neighborhoods. And so I was looking at Metro, and then Preston Park, and then Marvilla, which is over in the Minneapolis side. And I just, I had, because I used to live in that road, so I had neighbors, just 2 blocks from where I used to live, or where I used to have a house. So I just felt like it's friendly, houses, I like.
I want Barry to see gold.
Dorothy is there, right?
Yeah, she's in, yeah.
Well, these guys are so gold. These guys back.
South.
Yeah, yeah.
I'm supposed to say that.
Yeah.
I know, I've been living in Northfield for years.
No, I was thinking of.
Yeah. Oh, yeah.
It just seems like such a daunting task. right?
Well, I lost her in the house. And so I called him this time and I said,
That'd be an interesting thing
this
to
house is on the market. Don't make me this house. I know where she's. So like he got me in and stuff. I looked at it was so sound, it's like good. It was so sound. So they call her. Yeah, it's probably. You know, so,
Oh, we have two different shifts.
you know, it's got a garage that needs some.
Oh, it's right there.
Yeah, yeah. But it's, you know, it's acres and things like that.
Well, work all day and I'm spending 3 hours.
Actually, I was at home today.
Good, that makes me feel a little better.
I could work from home. So I was.
Great.
So I was able to reports. I had a faculty meeting.
We have to be careful.
So it works out.
Last break is two.
This is fun.
Hey, we're gonna start again.
Oh, yeah. So then.
Okay, so the question comes up about treatment rights, and somebody's raised this question. Can you force somebody to get treatment? And basically, all patients have a right to refuse treatment, and they have the right to withhold or withdraw consent for treatment at any time. So one of the things I want you to notice, when you've been out on the floors, the med-surg floors, right?
Yes.
Have you ever seen patients refuse medications?
Yes.
What happens?
Sometimes we ask them later.
Okay, you ask them later.
We try to reason with them.
You what?
Chart it.
You chart it. Do you see nurses ever try to tell patients they have to take the meds?
I work on in a dementia unit.
Oh,
and
okay. Salesmanship at that point.
Yeah.
Okay.
Yeah.
Yeah. They try to sell it. I've had staff, I was a clinical risk manager, which in risk management, you get all the phone calls about the legal stuff. And a staff called up and says, this patient's refusing their medication. You have to tell them they have to do it. I'm like, well, they can refuse it. And the staff get all bent out of shape. But what you'll notice on the units with in mental health is the staff or a patient refuses medications, the staff just go, okay, and they chart it and they go on. Now that becomes part of their, report in the treatment plan, and he's refusing meds again, and so there's maybe some negotiation. But you don't see people fighting over it, trying to force the patient to do something. And I see that more on the mental health unit, where nurses and staff are respecting that patient's right to refuse. But that's important to remember. It's also important to know that you have to have informed consent, that you have, prior to treatment or procedure, get consent. And the presence of psychosis does not preclude this right, okay? So just because somebody's psychotic doesn't mean you have the right to just go ahead and do things. Sometimes you have to get the permission of the guardian. If it's a child underage, you have to get permission of the parent. Sometimes if the patient has dementia or something and you want to do a treatment, it is the guardian that gives you that right to do that. We can, in our state, there are a couple different laws you need to know about. One is a Jarvis hearing. And this is to determine whether or not a patient can be forced to take psychiatric or psychotropic medications. This is only for neuroleptic medications and only if the patient is dangerous. Okay, and so what you'll hear is you might have a patient who's in a commitment process, and then they have a Jarvis hearing. And the Jarvis hearing is a hearing to determine, can we force that patient to take, and it's typically an antipsychotic or the neuroleptic that's treating a psychosis or schizophrenia, that we're gonna force that patient to take the medications. But only a court can order, only a judge can order forced treatment. And so that means you can't go in and say, we want to force this patient to take antidepressants. You can't force somebody to take an antidepressant. It's only an antipsychotic, and it's only if they're dangerous. You know, the Gabby Giffords case, where Gabby Giffords was shot by a young man that had schizophrenia, they did do a court hearing, and they forced him to get forced treatment so that he could become competent to stand trial. That you can't really try somebody who's mentally incompetent, because what you've got is you're not guilty by reason of mental incapacity or mental or insanity. Depends on the wording in your state. But they can force, the courts can force somebody to take medications to the point where that person can become competent and help take part in their defense of, their actions. But in the case of patients with mental illness that are not in the court system, we have a Jarvis hearing to force them to get treatment.
So they can be forced to take their medication so they can stand competent.
That in one particular case, the case in Arizona, and it was a neuroleptic medication. It was an antipsychotic.
Okay, because if they weren't in their right mind when they committed the crime, what's the use in trying to get them in their right mind to have them?
So they can stand trial.
So they can like talk about it, like, oh, I was saying these?
Yeah.
Like, that's what you're talking about, like, oh my God, I was hearing these voices and they made me do this.
Right.
Like,
So I understand your question, and not all states will do that, and it's just, I need to shut up sometimes and not give you all these cases. I just was trying to use that as an example that the court is the one that says you have to take this medication. So the other hearing that you might hear about is a Price-Shepard hearing. And this is forced treatment. And this would be a patient who was forced to undergo electroconvulsive therapy, or ECT therapy. Not all states have this, okay? If you go to another state and you talk about a Jarvis hearing, they're not gonna know what you're talking about. That's particular to Minnesota. Price-Shepard hearings are particular to Minnesota. So other states may have a similar law, but this is the one from Minnesota. It's rarely used today, but it was used a lot in the 70s. We are seeing a comeback of electroconvulsive therapy, but I don't know that we see much still of these Price-Shepard hearings. So I just want to move to competency, because that's always a question. Are patients competent to make decisions for themselves? And the point I want to make about this is that competency is something that is a legal proceeding, okay? As staff, doctors can't determine if somebody's competent or incompetent. It's a court that decides is somebody competent. If somebody is incompetent, and that means they can't make decisions for themselves, they have a court-appointed legal guardian who's responsible for giving or refusing consent, refusing consent. It's never the care provider who's the legal guardian, okay? And if you have somebody you decided, you question whether or not they're competent and they need to have a guardian appointed for them, you can actually, there's a 24-hour process that's available to get an emergency guardian appointed until there can be a hearing for guardianship. I saw this more in Alaska where the doctors would say, we have nobody to make decisions for this person, they're incompetent, so we're gonna go ahead and do this treatment. And we're like, no, you can't do that. We call the magistrate, they will appoint a guardian, that guardian will make the decision. Now, more often than not, the guardian will listen to the physician or the provider as to what care needs to be given, but it has to be the court that makes that decision or the guardian, because otherwise you have a conflict of interest. So just keep that in mind. And then mental capacity determination is offered by the psychiatrist or the psychologist. So at these competency hearings, mental capacity, their ability to make decisions, is testified to by a psychiatrist or psychologist. Psych mental health nurse practitioners might be doing that now, but they go in and they give their testimony, and then the court decides whether or not that person's incompetent. So I just wanted to put that out there too. Consent, it's informed. There's two types. Informed, you know about, where an invasive procedure. There's implied consent, and people, you know about it, you may not have thought about it. And that is that if you go to do something with the patients and they agree to it, they're giving implied consent. If you go in to take vital signs, they're giving implied consent. If you're giving medications, it's implied consent. So those are the two things that you'll hear. So seclusion and restraints. It's governed by the federal statute, Medicare and Medicaid programs, and it's a condition of participation, which means hospitals have to comply with this law. For mental health patients, you can only use restraints if the patient is imminently dangerous to self or others. And you have to try least restrictive measures first. And you have to use the least restrictive restraint. And it has to be in the shortest amount of time. So let's use an example of the patients up on your floor that have dementia. That these patients are getting combative, and we're deciding that this person's going to be dangerous to the staff. Do we need to put 5-point leather restraints on this little person who is just kind of punching at your face? Now, some of them you might need to, but for most of them, maybe a soft restraint would do. And maybe it's only for 5 minutes, okay? But that's what it means by the shortest amount of time, the least restrictive restraint. If you think about your med-surg patients, if I have somebody that's scratching themselves, and I don't want them scratching a wound, and they're, let's say they're in a coma, but they're doing it involuntarily, I put on mitts. They can still move their hands around, they just can't scratch that. So in mental health, it's the same principle. We use the least restrictive measures first. We try to talk to the patient. We might say to the patient, you know, John, it looks like things are getting a little intense for you. It looks like you might be getting out of control. Would you like to go to your room and spend some time there? Would you like to go to the quiet room? So you try to do those interventions first. And if John's escalating or it becomes evident that John's going to need more than that, then you can move to maybe going to the seclusion room. And then it might be going to, if John's going to get physical with somebody or starts to get physical, then you might need to restrain John.
Where does medication fall in that like line of restraint? Like when is a medication restraint? Or is it?
Well, a medication's restraint, if you're a chemical restraint, is if you're using that to limit that person's behavior.
Okay.
So typically if somebody's getting, let's say, and there's a fine line with that because mostly it's going to be the antipsychotics, but it might be something they're also scheduled to receive. It might be something that we're using to treat them. But in the case of a patient that gets out of control and is dangerously violent, and we're using that to get them back under control, that's going to be considered a chemical restraint. It's not being used for their therapy. So just to go over and this is I know in your book, for behavioral restraints orders, for med-surg restraint, you can have an order that lasts for 24 hours. You check on the patient every couple hours. Well, for behavioral restraint, it's a 4-hour time limit for adults, 2 hours for ages 9 to 17, and 1 hour for under age 9. And it's a total limit of 24 hours. So you can have the restraints repeated. So after 4 hours, you get another order for a restraint, but you're limited to 24 hours. Once the patient's calm, you need to do, or if the patient's, you take the patient out of restraint once they become calm. You don't leave them in that restraint for that whole time. And a licensed independent provider must do a face-to-face with that patient within an hour. Yeah.
What was an LIP?
Oh, LIP, licensed independent practitioner. So that could be a psych mental health nurse practitioner, it could be a PA, it could be a physician. Why do you think the time limit is so, one, different for behavioral restraints, and then two, for each of the different ages?
So it's how long that age group can probably mentally stand to be restrained.
Right. So for the ages, it's about how long that group can mentally tolerate that. So why the difference between behavioral and adult? Why don't we have orders for 24 hours in behavioral? Why do you think?
Potential for abuse.
Okay, there is the potential for abuse. Think about for the patient. Why do you think that might be more dangerous for a patient? What's going on with the patient?
And they're already kind of out of feel a loss of control.
Right, there's loss of control, they're angry. What were you saying, they're frustrated?
They're feeling frustrated that they can't get out of, and that just escalates and escalates and escalates.
Right.
And by the time it's time to release them, they're probably worse off than you were when you put it back, when you put it in.
Well, that could be, think about, yeah, it could be that.
So I just know, when I was, way back when I was a CNA in the early to mid-90s, we were still using restraints in nursing homes.
Yeah.
If somebody was a fall risk. And especially if you had on the heavy dementia unit, people would just be more agitated
Right.
when it was time to release
Okay.
them than they were ahead of time, and your behaviors were worse.
Right. So that's what I was getting, I heard you differently, but, sometimes the restraints make people more out of control. And the whole purpose of the restraint is to help that person get in control. And so when somebody is out of control behaviorally, you need to be intervening to do something to help them regain control. So it's not just, we're gonna constrain you because we want to keep you in place, and that's another reason why we don't do 24 hours, because we don't want to abuse it. But this person's out of control, we need to intervene. We need to do something different with this patient. Maybe it's a medication. Maybe it's a one-time medication. Maybe we need to adjust their meds. Maybe this person needs to be in a different environment. So we need to intervene, and that's why a doctor has to come see, or not a doctor, but a licensed independent practitioner has to see them within the first hour. Because they need to come in and see, is this person on the right medications? Are they in the right environment? The other thing with these behavioral restraints is that anytime there's a death that occurs while a patient's restrained or in seclusion, or within 24 hours after they removed it, or within 1 week after, if they die, that has to be reported to the Centers for Medicare and Medicaid Services. And there are a significant number of patients that do die. Sometimes what happens is when patients are restrained, and let's say they're on SSRIs, serotonin reuptake inhibitors, there's a chance for malignant hyperthermia, and patients are getting worked up, and their fevers, temperatures rise. Physiologic things can happen to patients. And so one of the things is that CMS wants to know how many patients die while they're restrained, or within the time the restraints are removed, or if it's related to the use of that restraint. Because we're trying to look at and get a grasp on really that abuse of restraints. And usually those deaths occur because the person's still out of control and we're not intervening in some different way with that person. So they're using that to take a look at, are you providing care to the person with the mental illness? Seclusion is something that's only used on a behavioral mental health unit. And what that means is you're preventing that person from moving around. You're keeping them in a room. You're secluding them. The rule is to never use restraints with seclusion. You want to make sure that that person's being watched. The goal is to reduce the stimulation of the patient. And that's why you don't have restraints on them, because they're going to get more agitated if they're restrained. You want a calm environment. So they're in a seclusion room. There's nothing else usually in the room. And many places are going away from the seclusion room, and you'll see quiet areas. And there might be alcoves, or just might be a quiet space where they can go to de-escalate. Let's see what else. Privacy, you guys know about HIPAA, but there's also, I want to talk about 3 exceptions to HIPAA. One is for continuity of care. So when HIPAA first came out, I had staff call me because the ER was refusing to give reports to the inpatient staff because of HIPAA. And we were like, okay, you can give report, it's not a HIPAA violation. So any continuity of care issues, which is why it allows us to give report and talk to patients or to other providers. So that's one of the exclusions. So if there's information that the patient gives you and the patient says, don't disclose this, you're part of a healthcare team and you need to let the patient know that, I'm part of a healthcare team and this is important information. And would you like to tell the rest of the team, or I could convey this message? But I can't promise to not disclose information, because it's important that the whole care team knows what's going on with that patient. So continuity of care is one exception. Another exception, of course, is billing and insurance information. And then the third is day-to-day operations. I do a lot of quality work now, and I'm in and out of patients' charts, and I'm pulling data. And the whole purpose is for us to improve quality of care. So those aren't HIPAA violations for me to be going in. Now, if I said, oh, wow, I'm interested and curious, and I go into a chart, that's a HIPAA violation. But those are the three exceptions that you'll see with HIPAA. With HIPAA, in order for information to be released, other than those three exceptions, you need a release of information. And there is also generally a separate release of information for mental health records. In many facilities, patients or staff will have access in the med-surg areas, won't have access to the mental health records. Now, in some places they will, but in some places they have limited access. And the reason why is because of the sensitivity of the information. We want patients to feel like they can talk about very personal issues without fearing disclosure of that information. It can be very damaging. And then there also may be a separate release of information for chemical dependency and treatment programs. I just thought of something. When we were talking about consent and informed consent, there is now informed consent for receiving neuroleptic medications or antipsychotic medications. That because of the severity of the side effects of these medications in mental health units, a lot of times you will go up and check with your units where you're at and see, is there an informed consent for the neuroleptic or antipsychotic meds? Because the patients need to be told what the side effects are of these medications. They are permanent and they can be severe. So we're starting to recognize that we need to give informed consent. That's the, how severe the side effects are for men. So we're going to get close to the duty to warn here. And the duty to warn is the duty to protect third parties. This came from the Tarasoff case back in '74. And it says that mental health professionals have a duty to protect individuals who are being threatened with bodily harm by a patient. What happened in Tarasoff was there was a woman on the University of California campus in Berkeley who's had a guy that was kind of stalking her and was telling the psychiatrist or psychologist, it was a school psychologist, about her, and he didn't do anything to warn her, and she ended up being killed. And so basically the court said, if somebody's threatening bodily harm to somebody, you have a duty to warn that person. Now, if somebody's saying, I'm going to go, shoot somebody, who are you going to warn? But if somebody says, I'm going to go shoot John Smith because X, Y, and Z, you have a duty to warn. You can discharge that duty by notifying the police, warning the intended victim, and or taking other reasonable steps to protect the threatened individual. Now, if a patient's on the floor in a locked unit and they're threatening to go hurt somebody, you're going to report that to the treatment team, and they're going to make a determination about, how serious that threat is. This is really related to those patients that are coming through clinics and stuff. And I don't mean that they have to determine if you're inpatient about the seriousness of the threat, but you have a control over that situation. If that person's threatening people, they're not going to be leaving. You'll get them on a 72-hour hold and you'll do a court hearing. But there is a duty to warn somebody if you hear that somebody's threatening to harm somebody else.
Didn't that just come into play, like over the summer, there was a medical student or someone who had been a medical student, I want to say in Colorado, and had been seeing a school psychologist and had been making threats to harm.
It's a Colorado shooter in the movie theater.
Was it
Oh,
the
the
same one?
movie theater, yeah,
Okay.
yeah.
Yeah, and he had been making threats and
Right.
she didn't
Notify anybody.
notify the police or anything else, and they searched his room and he had all sorts of bomb making.
Yeah.
And
And we're seeing, and that's, people like don't want to get involved or they don't want to react. You don't have to prove that that person's been dangerous. You just have to report that. You have to notify. It's like, for vulnerable adults or suspected child abuse, you guys are required reporters. You don't have to have proof that it's definite that it happened. There's laws to protect the reporters, but we want to err on the side of protecting those potential victims. And so what can happen to you if you don't report? Obviously, there's liability. People can come after you both civilly and criminally. So it really is important that we're protecting other parties. And it is a tension. I mean, we don't have enough resources for people with mental illness. There's a lot of people with post-traumatic stress disorder coming back from the wars. We don't have enough services for those people. And, how do you take some of these, you don't want to judge, is this a serious threat or not? If somebody's threatening somebody, you have an obligation to report. And then let the police decide, if this is something that needs to be pursued. I think we're seeing that with a lot of shooters, that there are warning signs out there that people have ignored.
You brought up mandatory reporting. So I heard the question come up, when is it is there if a person is not actually like working in their employment at the hospital or or at their clinic or actually working as a nurse at a particular time. So some guys were arguing about, does a nurse or anyone else need to report? Are they under that mandatory reporting legal obligation?
That's a good question. The question goes back to the duty, and it says here, mental health professionals have a duty to protect individuals who are being threatened with bodily harm.
Doesn't limit it at all.
It doesn't limit it at all. I think, this is a legal field, arguments could be made either way. If you overhear something, the question is, if you overheard somebody, like, I'm trying to think of this, let's say you're in a supermarket, and you overhear a conversation, somebody saying, I'm gonna go home, I'm gonna teach my wife a lesson, I'm gonna beat the crap out of her. Okay, do you have the ability to really assess that situation? I mean, that's part of the issue. Is this just a comment? Is this guy blowing off steam? Is this a serious threat? Yeah. In the situations where we're talking about this in this Colorado shooter, they're in that therapeutic relationship. The person is really has the opportunity to ask questions and really determine, is this a credible threat or not? Yeah. So, I guess I'd look at it from that perspective. How much do you know about it? How much do you want to get involved? If I see somebody, that, like, I've done this where parents are like beating on a kid, I'm going to stop them and say, what are you doing? And usually that attention is going to get them to stop. Now, if I hear, threats, if I hear somebody overhear a conversation and somebody says, yeah, I've got the stuff in the car, I'm headed over to wherever, I'm going to call the police. I think those are those gray areas. But if you're certainly in a therapeutic relationship with a person and you're a mental health professional, you have that obligation to warn. There have been other cases where it's really the spouses where they go home and will harm their spouse, and somebody's known about that. And what happens to providers? It's a tough line. They get overconfident in their skill set of determining who's dangerous or who's not dangerous. And what the court system wants to do is take away that I'm going to predict this. Take away the human factor of prediction, saying you report it, and then you've discharged your duty, and then if something happens, that's okay, or not okay, but you've done what you've needed to do. You may have a question.
I'm just wondering, how often does this come back and come back and bite? Someone goes through a terrible divorce and makes a comment about how they just wish they could run their ex-spouse over with their car. They are blowing off steam, but the spouse has now been notified. That becomes part of the case. They've lost the relationship with their psychiatrist now. Now that the police are involved, like, does that come back of that's a violation of my privacy? This is actually slander or libel because I didn't mean it, because I wasn't in that moment, you know, like, how, I say some crazy things sometimes, and I'm just, I mean,
Yeah.
it seems like.
Well, and that's the skill set of the professional that's doing the assessment. Is this person blowing off the steam? Is this something I need to be concerned about? I mean, the argument of the psychiatrist or psychologist was, oh, I thought they were blowing off steam. If you have a specific threat, the more specificity to the threat, the more capability of carrying out the threat, if there's been a history, those all come into play. And it is a decision of that provider that do you do this? So, you know, that's a very tough thing.
I feel bad for this psychologist or psychiatrist, because when I read it, the girl moved to South America and was gone for an entire year, and the patient kept seeing the psychologist and never mentioned it again. You're like, you know, you would never think that would be held on for a year, and I can very easily see that making that error.
And that happens. They make the error, but the law came about because, and this was 74, so this is many years ago. There are, you know, and well, I won't say each state's different, but there is some differences between the states in how the law is interpreted. You know, I like talking about these things, but it's also one of those. A lot of it depends on the specific facts. It's like the McDonald's case. How many people heard about the McDonald's coffee case and the millions of dollars?
Spilled the hot coffee on her lap and she sued because I didn't know the coffee was gonna be hot.
Right. Well,
you didn't warn me. That's literally why it says warning contents are hot.
So when you look into that case, though, this was an elderly woman who McDonald's, there's this industry standard for hot coffee. It's like 120, and they set theirs at 160 intentionally because it brings more out. So they were above the standards. They'd had numerous cases before where people had sued for spilled coffee or for burns that they got from their coffee, and they had paid those out. And all this woman wanted was her hospital bills and costs paid. And when they didn't do that, she got an attorney who sued. Yes, she got millions of dollars, but what they did was the jury is the one that decided how much she gets. And it was the punitive damages. The punitive damages was the profit that McDonald's made off of their coffee for one day. That was the punitive damages. Now, you can't punish somebody unless you make it hurt. Well, one day of profits isn't that much. So then it goes through the appeals process, and once it was all paid out, this woman got about $112 more than her medical costs. But people don't know about the facts of the case, and that's what's difficult about some of what's out in public and what's in writing and what's in the text, until you get down into the facts of the case. So it does make things, you know, a little bit different. And I'm not saying this case, it does seem like, well, she was gone for a year, and how do you do that? But the point is that you do have a duty. If you feel like somebody is being targeted and is in danger, you have a duty to report it. You know, as far as HIPAA goes, it is an exception to HIPAA. If I'm sitting in an office or I'm in a clinic and somebody's threatening to go home and kill their wife, now they're in the group room and everybody's hearing this, you know, how much credibility is there? But when I talk to patients, you could say, you know, if I'm not going to, you know, report anything or I'm not going to disclose anything unless I'm required to. So if I'm working with patients and they disclose that they're going to harm somebody, or if they disclose they've abused children or adult abuse, I'm required to report those. So a lot of times when you're working with patients and you'll hear practitioners say, you know, everything will be kept confidential unless I'm required to report it, which then creates a situation where you've got patients that they have to think about, am I going to disclose this or not? You know, what am I going to do? So you've got a lot of this tension going on, which makes it, you know, kind of an interesting field, but kind of a difficult field. I mean, we're making tough decisions. Mental health practitioners are making very tough decisions out there. This is the last thing I was just going to talk about, privileged communications. And that is for privileged communications, there's communications that can be kept private between two people. And that means that if a court case happens, you can't talk about what was discussed. So there's the attorney-client privilege. So anything a client says with client says with the attorney cannot be disclosed in court. Doesn't have to be disclosed to the other side. So if you have a patient that's going through commitment hearings, what that patient shares with his attorney or her attorney is kept private. Okay, they don't have to tell you what was said. So, don't ask them, well, you can say, how did it go with your attorney, but don't tell me what don't say to them, tell me what your attorney said. Physician-patient has that therapeutic privilege, that anything a patient discloses to a physician can be kept private, with the exception of those required reporting things. A priest penitent or parishioner, things that a parishioner tells a priest does not have to be disclosed, again, unless it's a required reporter. And priests are required reporters for vulnerable adult and child abuse. There's a marital privilege communication, which says that if I tell my spouse something, I don't have to testify against my spouse. I can, but I don't have to. And now that we have gay marriage in our state, if it's a gay marriage, you don't have to say anything that was told to you. If you have a gay couple but they're not married and you get called into court, you would be asked to testify against that person. So marriage provides that privileged communication. And then the therapist-client. And in Minnesota, we do recognize nurses and patient with that physician-patient relationship. We want people to be able to have people they can consult and share very private things and not fear that that's going to be used against them with testimony. So I just wanted to throw that out there. That's kind of all I have. Do you guys have any other questions? We made it through everything.
I have a question. This is from previous with HIPAA.
Okay.
I thought of this. This is something I dealt with yesterday during our simulation situation. But it's really uncomfortable when a family member tries to ask you questions.
Mm-hmm.
And you can tell if your patient isn't necessarily in the right mind, but also does that family member have the right to ask those questions? Like, what are medications for? What's wrong with them? Things like that. I don't have a problem with, I have a problem with giving that information.
Okay.
Because, where is that line of HIPAA? Should I tell them what that medication is for? Is that telling them about what this condition is? Do they have the right to know what this condition is right now?
Okay. And
are they their guardians?
Is this a family member? Is the patient, does the patient have legal capacity? Can the patient give consent for sharing that information?
I mean, it didn't seem as though they could. They were able to make any decisions for themselves, the patient.
Okay.
But I'm just saying, for those type of patients in general, how do we know that this is their family member, that they're,
Well, and that's a good question. If you have family members calling in, let's say, and you're not able to identify who they are on the phone, you basically could say, I'm not, I can't disclose any information unless I have written consent by the patient to disclose information.
And that can make daughter was present.
Right. This situation was a post-ORAF, going into alcohol withdrawal. It wasn't clear to us as the students it was alcohol withdrawal.
Mhm.
Daughter's been there the whole time.
Daughter's the caretaker.
Okay.
She's
the
next
daughter.
to
Yeah,
So she's the
no.
caretaker.
and the daughter
How do
is,
we didn't know that though, it didn't say no guardian or anything like that. That information wasn't given to us. That
Okay.
she was a guardian. It just said this is her family
No,
member,
it's that
this
she's
is
the
her daughter.
caretaker.
Right. So is this a scenario that you guys had in the last?
Yes, but I'm just saying in
Okay,
general.
so in general, okay.
But I think
You
you was more like
cannot-
in person than on the phone.
yeah, I
think
mean, it
that's what
wasn't a
Yes.
phone call, it was she was
Okay.
sitting right there.
You cannot disclose information to anybody about a patient without the patient's consent. Now, if you're in a room, remember there's implied consent. So if you're in a room with a patient, the family's there, and you can ask the patient, is it okay if I disclose this information? And then they can say whether or not they give consent. If a patient is unable to give consent, then there should be a proxy. Who's the decision maker for the patient? There's always going to be a proxy. And so let's say we have a patient that comes in the emergency room, they're in a coma, or they're not able to answer questions, you're not sure if they can give consent. Do they have a durable power of attorney of healthcare on record? And if they have that durable power of attorney, that's the person you talk to, and you ask that person, who can we talk to? Who can we give permission to or information to? If there is no power of attorney, the laws in each state have a listing of who can be the decision maker for that patient. So it goes down and it would be like the spouse, it would be, if it's a parent, it would be the child, it would be the spouse, it would be the adult child, then it would go down to like adult children, it might be then a sibling, and there's a list within the laws that says who the decision maker would be. So you go down that list. So if somebody can't make decisions for themselves or they can't communicate to you, you have to have a decision maker. Because let's say we get the person in an emergency room and they're stabilized, and the doctor says, we really need to take them to surgery to fix their fractured femur. Okay, it's not an emergency. They could fix that fractured femur somewhere else, or so you have to find who's the decision maker that can give us the consent to go ahead and do the surgery. Now, they can do the emergency surgery type pieces if they came in with a head trauma, and you don't need that. But you have to find who the decision maker is, because we don't want the healthcare workers to be the decision makers for care. So once you identify who the decision maker is, then you would say to this person, who do we have permission to give information to? We ran into this a lot in Alaska, where you would have marriages, people living together, and the person would say, well, I make her healthcare decisions. We don't have a POA. We had to go with the parent. She didn't have a spouse, so you go with the parent. If she didn't have a parent, we would go with an adult child. She didn't have an adult child, we would go with a sibling. But there's a lineage that's set up for that, and so it creates frustration on the part of somebody who's been with that person, but that's what the law says, that you can't disclose that information. Most of the time, if you explain it to people, they're going to understand that. Some people will get very heated about it and say, I have a right to know. Bless you. And that's where, if you get in that situation, I would say call your risk manager and say, hey, we have this situation here. We don't know who the person is that is the decision maker for this person. But if you go into a room and there's somebody there and that person's asking questions, you would just say to the patient, is that okay if I share this? And the patient can say yes or no. Now, it would be uncomfortable for the patient because the patient's going to probably not want to say no with the person sitting there. So it's always a good idea when a patient comes in to figure out, who can we share information with. When I was an HIV clinical specialist, my ID badge said hematology because many of my patients had not told their family members they had HIV. And if I were to wear that in the room, they would put two and two together. So they saw hematology. And so they would assume they were in there, oh, it's related to blood. We dealt with that. And so I was always very careful to say who knows, who can be told what. So that's that situation. In the situation you're describing, I would find out, does this person have a healthcare power of attorney? And then I would, as much as the patient could consent, I would ask that patient, is that okay if I share the information? Remembering that lack of capacity, is only decided by the courts. It's not decided by the, healthcare providers. And particularly when somebody's drunk, that doesn't mean they're lacking capacity. It means, they might be impaired, but it's not gonna rise to that legal level of incapacity. Does that make sense? I know it's tough. I mean, you deal with a lot of tough situations in healthcare.
I was just actually on healthcare directives. In Minnesota, there doesn't seem to be a whole lot of opportunity to talk about what kind of mental health interventions would be preferred. What kind of stuff do you see or do people actually complete and put on file for their healthcare directive that include mental health?
You know, it's actually a new area where some people have included mental health directives on those healthcare power of attorneys. I would say that, I don't know, I can't really address that fully, but that is something that people have mental illness that they need to put within there. And you can put in there, you know, well, mostly with healthcare power of attorneys, they only become active if the person's unable to make decisions for themselves. If I'm fully capable of making decisions, you can't be making healthcare decisions for me. So that's the whole purpose of that healthcare power of attorney, is for when they're lacking capacity. But there could be situations where it addresses like the mental health treatments, and that would be something that needs to be specifically stipulated. So I don't know if that answered that.
One of the things I just wanted to mention concerning the question about the mother and daughter, and I think because, you know, I've worked in a acute facility, one of the things I forgot to mention is we're really in tune to who the patient has given permission to. I mean, so in that case, almost certainly, if the daughter was a caregiver, she would have given consent for her daughter to have information. And so, you know, I think that I feel like we're always really aware when visitors come, if that visitor has consent, if that patient has consented. So, you know, I would think for sure that that daughter would have been given consent.
So this was in the
But you do have to know that.
Yeah. Okay.
Yeah, but like, because I'm thinking of some people, some families are real talkative, and so maybe they have multiple, maybe a sister is their power of attorney or their caretaker, but another sister comes in, and I'm her sister, and so they ask you, well, what's that medicine for? And I'm just thinking, like, what if it's for bipolar, and they Google that medication, you know, or you say, you tell them what the name of the medication is, even and Google it's bipolar, and then they talk to their little coffee group or whatever, and I'm just seeing how things can be skewed so easily from just telling someone what a medication is. You know, what are you giving them that for? I used to work for an insurance company, and so I, like, HIPAA is like, just zip it, just, you know, that's what we were just ingrained in. If someone calls, it's not that person, you just zip it. You shouldn't even tell them that they're a part of your company, let alone, you know, that. So I just, it's really uncomfortable ground for me. I was really uncomfortable because I'm like, you know, if I was in that position, I would want to know what's going on and stuff like that. But maybe that parent didn't want their child to know these conditions. That happens with, I know I've dealt with that with a family member with cancer. They didn't want anyone to know they had cancer.
Well, and that's what Lori's saying is that you're gonna know who it is, and if you don't know, you need to find out.
Yeah.
It needs to be part of that record, because that will happen where you have some family members that want to know and they don't want other family members to know. And what we don't want to get, just like we don't want to be police, we don't want to be family court.
Yeah.
You know, you can very politely say, you know, we have permission to disclose information to Susan. And one of the ways to get around it is you know, say, we need one spokesperson for the family. It can be the power of attorney or not, but we want one spokesperson for the family. Even if the patient is able to talk and has capacity and is making their own decisions, and you've got other people calling in, you've got all these family members that are concerned, we always say we want one person that we can talk to, who we can give information to, and then that person is responsible for talking to the rest of the family. That's where Caring Bridge comes up and some of those other things, that people can put what they want out there and not bother the patient, not bother the family, not bother the staff, and it's a way to keep that out there. So whatever they put out there is what the family puts out there, whatever the patient wants out there. To try to avoid some of these situations. Because it is difficult. But you have to know who do we have permission. And usually if you have a lot of people asking in the family, you can ask the family, you know, can we just have one spokesperson to talk to? And that way it's consistent information and we can stay out of the middle of getting into the family feuds that happen. Thank you, guys.
Thank you,
Thank
Deb.
you so much.
Great. Class is not over yet.
Change that situation with skill set.
Sorry. I just, sorry. No, I mean, it's not gonna be long, but I have a couple things that I wanted to go over.
I got it. If we get the soybeans with the chemical,
Well, if your mom.
thank you.
Oh, you're welcome. Really appreciate it. No, you were great, thank you.
I like it.
Okay, I'm just gonna talk to you just for a minute. Dorothy is passing out 2 articles. One is, they're both very short, and I had one of them tonight, in case Deb did a 2-hour lecture. But I want you to read them, and I'm gonna be posting something on D2L for a lab activity next week related to these. This is legal. I know the print is really small on one, but I couldn't get it bigger. But I just want you to read this, and then I'll post what I want to do with it. The other thing is, I know you have a test this Monday, right? Yeah. Yeah. So there's just a couple things that I kind of want to go over and make sure you guys are like on track with. Extrapyramidal symptoms. Does anybody have like questions about the terminology or, I mean, there's different terms, dystonia, akathisia. Are you guys clear about this?
That's decreasing the dopamine, right? What does it result from?
Well,
Big side effect.
we're just talking about extrapyramidal symptoms right now, related to antipsychotics.
Okay.
So I just want to make sure you guys are aware of the language, because akathisia is also called restless leg syndrome. So that's another word for it. I mean, it's really important that you read your book. It's sometimes it's called the walks. It's real anxiousness, shaking of your legs. I mean, moving a lot. So I want to make sure you're aware of that, as well as dystonia, which is usually the neck and jaw muscles. So, you know, if you see someone doing something like this, that's dystonia. These are terms that I want to make sure you're looking up. And tardive dyskinesia, we talked about that, and that's like the worst and permanent. The mouth movements, mouth and jaw and tongue smacking. So if you have any confusion about these, you should go on YouTube and Google akathisia or Google dystonia, and you'll see what it is. I want to make sure you're kind of aware of neuroleptic malignant syndrome and what the key indicators are, so that if you see a patient that's having some symptoms, you can know that this is neuroleptic malignant syndrome as opposed to something else. So I would focus, you know, on what the key indicators are.
What do you think the key indicators are of this?
Well,
There's a list.
What?
There's a list.
Okay, so what is the list? Like, what are the first 3 things on the list?
Hyperthermia, muscle rigidity, cramps, tremor.
Okay, so hyperthermia, you know, a highly elevated temp would be a pretty significant sign. So, you know, when we give symptoms like that, I'd look at the first 2 or 3.
Okay.
I want to make sure that you're aware that, you know, like, how long do you think it takes for antidepressants to work?
2 weeks, at least.
Well, the
So I'm hearing lots of different things.
The SSRIs take weeks.
How many?
Okay, but we got to be more
2
specific.
to 4.
Okay, 2 to 4.
The Davis Drug Guide for all those SSRIs said 1 to 4 weeks. And it said like, it's 2 weeks you should see improvement and 4 to 6 weeks you should see full effectiveness.
Okay, and that's why, you can see improvement in 2 weeks, but most antidepressants aren't considered really at capacity until about 4 weeks. So that's important.
Therapeutic level.
Yeah, to get to the therapeutic level.
That's not really measurable though. So how?
By behavior.
Well,
Behavior.
it's generally considered antidepressants take about 4 weeks to really reach maximum effect.
So hone in on those therapeutic level reached by,
Behaviors.
so by X amount of time in the
Right.
Davis Drug Guide.
Right.
Is that true TCA of all of them or just the?
Yeah, I mean, I want you to think of antidepressants as
Okay.
taking about that long. And I want to make really sure you're clear about refusing medications. I mean, I think Deb covered it really well, but, everybody can refuse medications. The only time you can't refuse medications is if you have a Jarvis. And a Jarvis is only for neuroleptic medications. That's really important that you know that.
And what's
And-
neuroleptic?
Antipsychotic.
Muy bien.
And where I work, I mean, Deb said, you have to have consent. And she said, it depends on your facility. I know at Alina, we have to get a written consent for neuroleptics. So.
To start them.
I think you guys are really clear about privacy and HIPAA. I don't think there's anything we need to talk about there. I wanted to make sure you knew the difference between battery and assault. I want to make sure you're also aware that medications are really, and you should know this, really affected by the age of the patient. The very young and the very old are going to be, very different. I want to make sure you understand the term elopement. Is there anybody that doesn't know what that means? Okay, so if a patient leaves the facility, if you're voluntary and you leave, would that be considered elopement?
No, that's against medical advice.
Or it can just be a discharge. But if you're on a hold or you're in a locked unit and you get out, that's elopement. So, I mean, what do you think, what would you do if you found out your patient had gotten out? What's the first thing you would think about doing? Okay, that's pretty good.
Tell your
Call 911.
supervisor.
I think a lot of times security ends up calling 911.
But what would you do? You're a staff nurse on a unit.
Charge nurse.
Tell the staff. Get all the other staff involved.
Look for them.
That's a good one. No, really, I'm serious. This is Angie. Get out.
Well, we have,
And
Well,
that's an elopement code.
We have a really,
you have an elopement code?
Yeah.
Oh, see, Alina doesn't.
we have very specific, everywhere I've been has very specific step-by-step instructions, like you have to do this and this, and then you do this, and.
Okay, so let's just pretend,
There's no
that
phone.
you don't have that. I mean, who would you call? Who would you call?
In a hospital setting. How about
Yeah.
that?
Operator.
No.
I'd wait on that one.
No.
Physician, the police.
No,
Who would you call?
Front
No, no.
desk.
no,
call him a super, I'm talking to my supervisor.
no,
Call him Mr. Obama.
no. You call security.
That's not-
I
that's not-
know, you said it before. You call security. I think that's really important. You don't call the psychiatrist. The psychiatrist might be golfing. What's he gonna do? What's she gonna do?
Gonna be, they're not, maybe they're gonna be.
Okay, so I just am thinking, do you guys understand the term duty? Like, who nurses have duty to? Like, who is your duty to? Is it the facility, the doctor? Who's your patient? Okay. That's really kind of basic, but your duty is to your patient, and you just have to always remember that. And another concept I want you to understand is when you're in a hospital setting, the psychiatrist on a mental health unit is the primary provider. So let's just say your patient says, I'm having severe chest pain. Do you go to a medical doctor or do you go to your psychiatrist?
For the primary.
you tell your psychiatrist, because that person is in charge of that patient. And then they will tell you to do something else, or they'll call. I mean, I'm not talking about a code, I'm just talking about, or somebody says I have really bad leg pain. That is, you take that to your psychiatrist. I mean, because a psychiatrist is a medical doctor. So I don't want you to think this provider is only about mental health. I mean, they're gonna get in a consult from an internal medicine doctor or orthopedic, but your concerns, even physical, go to your psychiatrist. Okay? Let's see. Oh, and I wanna also make sure, and I think Deb covered this really well, but be sure you understand the guidelines for involuntary commitment. You know, who can be committed involuntarily? People who are a danger to themselves, a danger to others, or who can't manage themselves, feed themselves, clothe themselves.
Just of note in regards to her presentation, it's in a PDF form right now, and Eric was able to get it to print. It sat there for half an hour trying to print. It was flattening. So if there's a way we can get it into
we will.
PowerPoint or something, I'll get some. Thank you.
So those are the things I really wanted to cover. Make sure that you're aware of the major, the list of medications and what neurotransmitter they target. That's very important. So yeah.
Did you want us, I know the PowerPoint that she went over the first part was a lot about biology and the biology behind the neurotransmitters and stuff. Did you want us to know that as well?
No, you don't have to know the pathophysiology that much, but you do have to know, you know, what neurotransmitter does Geodon target. I mean, those are divided into big groups on that sheet.
Yeah.
And, you know, it's really not, I'm not asking you to memorize that much, but you need to know, you know, what do the antidepressants target? What do the antipsychotics target? Because that's really just basic, yes.
Sorry, you can finish your.
No, that's okay.
In addition to that list of 42 meds in the one PowerPoint, there are additional meds that are not on that 42
Is that
list.
in addiction?
Yes.
Yeah,
It's
well,
in the
whatever
PowerPoint.
Dorothea talked about in
You're
addiction.
referring to Vaccarol is what Marcia used?
Yeah. Well, and
Only the 42.
well,
Okay.
she also you know made some notes on specific drugs that don't appear on the 42. So then it made me think, oh well, that's another one I need to know too, because she specifically said something about it in the lecture.
I think it was more that appear in those classes that she was getting at in the PowerPoint.
I don't believe that there's anything.
Focus on the 42.
Yeah,
list.
Focus on the 42. Thank you, that's what I need to know.
And add to it from that PowerPoint, add details from that PowerPoint.
Just not extra meds.
Right.
For sure.
So,
Yeah.
I'm
Really?
trying to come up with, like really good notes she gave us.
So that's what I really wanted to cover, and I also wanted to take you across the hall to the Panopto lab, and, you know, we've got to get that in the beginning of next week, because for people who aren't comfortable with doing it, I want to go through the steps and show you, so you don't have any anxiety about that assignment.
You've got time to. It's an interview.
Right.
You still
Yeah.
have time. It's probably not on
And
your
it's
radar
not
yet.
hard, it's not hard, it's easy, but it's gonna seem a little tricky unless you know the steps.
And we're gonna get assigned groups.
Nope, you create your partner and you contact,
Do we do that just at any point during?
yes, and you contact Jesse to get the key to open up the door
So there's
and the
not a-
time.
There's a specific due date, but it's not, we're
And
handing
you
it
can
out
do it
now.
tomorrow if you know how to do it.
Yeah.
Gotcha.
Do you have any other questions on the exam? You get the therapeutic Malou stuff, what it's about, what happens, what patients do, what's the nurse responsibility? Guess so.
Ready? That's good, take it now.
All right, thank you. Thank you.
What about the different community treatment options? We need to be really, because there's like, 10 different options for like integrated or different.
You just need to know that they exist, you don't need to memorize them.
They all have different acronyms.
Really? I can ask you. Super terrible, but like, here's an example of a drug that she
But it's also,
You know what I mean? Yeah. That's, I mean, it's just an example.
Well, I guess, you know, definitely those sisters, yeah.
yeah,
I mean,
it's-
it's important to know, I was really specific with that. Okay. Difficult is an you know, so that's what you found.
Not only are you sure, but you never get the question. It says, as therapy, there is duels. There is no.
And, you know, honestly, on the tests, you're probably gonna get some of the tests.
Yeah, I'm terrified
And they're gonna be real, very
Yeah.
significant in their class.
No, look stupid like I do.
I think there's.
I mean, better was terrified.
This, you know, target. But,
Yeah, it was a start today. That's an old cup.
On the, court, or off the 14th, there we go.
I wouldn't know if it's anybody else.
Yeah.